to conduct the inquiry and to determine the appeal. We will come to the event management a little later on, but can I please ask that you ensure that your microphones are muted for the moment, and I'm happy for you to keep your cameras on though. I need to take everybody's name, so can I please start with the council? I'd like to know who is acting for the council.
Yes, good morning, sir. Can you hear me?
I can hear you, yes.
Good morning, sir. My name is Charles Streeton. I'm a barrister instructed by the Legal Services at London Borough of Hackney, and I will call one witness, that's David Daines, who is in the room, and as I look at the screen, he appears on my left.
Okay, thank you very much. Could I just check your surname? Is it Free Sun?
Streeton, spelled street, and then E for Echo, N for November.
Okay, thank you. And you're calling Mr. Daines as your witness. Can I then ask who is acting for the appellant?
Sir, good morning. My name's Ed Grant of Counsel. And sir, I'm instructed by Christine Hereward of Hereward & Co. Solicitors.
Thank you.
And I propose calling one witness who you can hopefully see on the screen, who is Julian Sutton of JMS Planning and Development Limited. And I trust his proof has reached you through the usual channels.
Yes, it has. Thank you very much. Are there any other interested parties who wish to speak? No. Okay, thank you. Is Mr. Sticken here? I can't see him. Okay. There was a letter of objection from Mr. Sticken. Did you get that, Mr. Grant?
Yes, I've seen that one. Yeah. Yes.
Thank you.
I think that was the only letter.
That's the only one I've seen. Yeah.
Yes.
Right, I'll go on to the other matters. The appeal is made by Timmings Limited under Section 174 of the Town and Country Planning Act, and this is against the decision of the council to issue enforcement notices made under Section 192 for the material change, Section 174 for the material change of use from residential dwellings to C3 to use as service apartments, C1. This is at 104 to 108 Curtain Road, London. The notices are for flats 1 to 21 and include flats 2A, 9A and 16A. I intend to sit for around about an hour and a half at a time before having a break. If anybody feels that they need an adjournment before that time, then please let me know. I think we've got a raise hand function here, so that can be used. And when we adjourn, if you wish, you can stay in the virtual meeting. However, please do not discuss relevant matters with each other during this time, as you may remain audible and visible during the course of that, unless you, of course, switch off your microphones and cameras. Also, I have to say, unlike a physical event, generally you can only see my head and shoulders, and I may be looking at papers, taking notes, or looking at a separate screen. This does not mean that I'm not listening. Similarly, when I'm watching you speak, I will be looking at the image of you rather than at the camera. So, and I also understand that it may well be the same for you. If anybody does suffer any IT problems and loses connection, what I will do is adjourn for 5 minutes so that you can log out and then log back in again. Hopefully that will resolve the problem. If we have any continuous problems with the technology, then obviously we might have to take other arrangements. If that does happen, I imagine what will happen is the case officer from PINS will contact everybody and then make all the rearrangements, but hopefully that will not occur. If at any stage you do have questions for me and you're not on camera, you can use the raise hand function on the screen there. I would also just ask you to make sure, I think I have as well, that your mobile phones are switched off, and emails, if possible, turned to silent to prevent disruption. After I've concluded my opening, it's better, I think, for the meeting if everybody switches off their cameras, apart from the two advocates and the witness speaking at that time. It can just help the connections and speed things up a bit. This isn't an enforcement case, and I think it started off with a ground D, and therefore evidence would normally be taken under an oath. I understand now the ground D has been withdrawn, but we still got a ground B, and there are some aspects of that which may be in the knowledge of the parties. And at the moment, I'm intending to ask the two witnesses to take the affirmation. Do you have any comments on that?
None from us, sir.
No, sir, we're content with that. Thank you.
Okay, thank you very much. I have the proofs of evidence from the witnesses and the other information and statements, etc., which have been sent in. And there are a few documents that were, I think, emailed in this morning, and I have received copies of those. Mr. Grant, have you received copies of those?
I was sent them by my learned friend at about 8 o'clock last night. I was asked also to pass them on to Mr. Sutton, which I did do. And we were both able last night to read through that material. Okay, so you don't need any extra time to consider it before you get on. As things stand, I'm not going to be asking for an adjournment to further consider the material. Okay. Unless there's a point taken arising out of them that I hadn't anticipated. Okay, that's fine. Well, thank you for that. Thank you very much. The other document that I received was the statement of common ground, and I sort of, is that an agreed document now, or I noticed there was some amendments on it? So my understanding was that at around the close of play yesterday, it was very nearly agreed. I haven't had an update actually overnight to know whether it is now agreed. I don't know whether my learned friend has any update on that.
So I believe that there is a version that was agreed this morning. No?
Not yet, no, I think we've seen it, but I think
well, it doesn't matter. I mean,
sorry, sir.
That's right. It doesn't matter. If I note it as not being agreed, then that's that. But what I'd say, it has been. There are obviously bits in it which are very useful to note, and I'll have that. I mean, the statement of common ground really is something that should be produced sort of well before, so that parties can not have to concentrate on certain aspects. But thank you very much for producing that.
So you froze on my screen. I don't know whether that was a problem at my end or if others found the same issue. But
did the council hear me?
Yes, sir, we did hear you.
Okay, I think it was at your end probably then.
Okay.
What I said was thank you very much for the statement on the ground. I'm going to note it as not being agreed at the moment. If you want to agree it in the daytime, then that's fine. But the benefit is before the inquiry rather than at the inquiry. If you see what I mean.
Well, so can I suggest that we endeavour behind the scenes, as it were, to have a signed version before the evidence starts this morning? I think that would probably be helpful.
It would be helpful, but it's yes, it would be helpful. But see how you go. Can I get on to the procedure? The procedure for today is, in summary, is I will set out what I consider the main issues in the case and any other items I want to hear evidence about. There may be other matters and facts that I've not identified, but that doesn't mean to say that you can't raise them. I shall then invite you, Mr. Grant, to have a brief opening of about 5 to 10 minutes just to set out the appellant's case. And then I'll ask the counsel to do the same. And then Mr. Grant will go on with your witness. And it will be the usual situation of examination in chief, cross-examination and re-examination, and I may have some questions then. And then we'll just move on to the counsel's witness and carry out the same procedure. After that, then we'll come to the conditions and see if anybody has any conditions that they want to be considered that might make the proposal acceptable, and we will go on to the closing submissions, and closing submissions will start with the counsel, and then we'll go on to the appellant to finish that. And after we've heard the closing submissions, I will ask if there are going to be any cost applications, and we'll hear them if there are, and we'll make the arrangements then for the site visit. Does that outline of procedure cause anybody any difficulties?
So none at all. And just before we get to openings, I should be able to send through to Pins and to the counsel the opening in writing, which will save your pen.
It will, yes. Thank you very much. That's okay from the counsel side. I'll move on. I did get some time estimates at the beginning. For the appellant's opening, I've got 15 minutes, and for the closing, 30 minutes, and for evidence in chief, 2 hours. Is that still correct?
I think 2 hours is I think I gave a bracket actually of 1.5 hours to 2 hours. I'd hope to be much closer to the lower end of that bracket, but
okay.
We'll see how we go, but hopefully towards the lower end of that.
Do you have any idea of cross-examination of the counsel's witness?
I would have thought a similar bracket.
Okay, 1 hour 30. Thank you very much. And can you give me your timings from the counsel, please? The opening, closing, evidence in chief, and cross-examination.
Yes, in terms of opening, I would think it's likely to be 5 minutes. Again, I have it in writing to save your pen, and that can be emailed around.
Thank you.
In terms of closing, I think probably an hour will be sufficient. In terms of evidence in chief, I would think an hour to 1.5 hours. I think I said 1.5 hours on the form. And in terms of cross-examination, I think that is likely to be around my estimate on the form, which was 2.5 hours.
Thank you. Right, what I'll do now is just come on to what I consider to be the main issues. Obviously, it's going to follow the grounds of appeal, and we've got the ground B, and that is whether or not the allegation is correct relating to the current use prior to the units being in their current situation. So the real question is, has there been a change of use? The counsel argue it was previous use for C1, and the appellant argues it was C1, and the counsel argues it was C3. But we'll come back to the notice in a moment. Then we've got the ground C and whether there's been a material change of use. And I think that probably is going to really relate back to ground B, because if ground B goes one way or the other, the ground C will pretty well follow the ground B, I would have thought. You're not going to argue if I find the appellant that the use was C1, then obviously there's no change of use. Would that be the counsel's case?
So obviously, if we found the use was C1, there'd be no change of use. But if the use was as a hostel, we do say that use as serviced apartments is materially different from use as a hostel.
All right, so we're going to have to look at that. And Mr. Grant, if it's the other way around, you agree that there would be a material change of use, or do you disagree with that?
Yes, we wouldn't argue that a change of use from C3 residential to serviced apartments is not a material change of use.
No, thank you very much for that. The ground D's been withdrawn now. The ground A is the effect of the change of use from residential units. Sorry, that's my dog. The effect on the character of the surrounding area and the effect on the living conditions of nearby occupiers, particularly at the 4th floor level. And then we have the ground G, which is argued that it should be extended from 1 month to 12 months. And I think the appellants have basically accepted that the ground F really follows the ground A.
Yes, that's right, sir.
Okay, thank you. Is there anything else anybody wishes to add to those sort of issues that we'll be looking at?
No, thank you.
So, I mean, the one thing that occurs to me is that there is a potential that the use is nil if there's been an intermediary change of use.
On what basis do you say?
So, sir, if the appellants were to accept, or you were to find, that there had been use as a hostel, followed by use as residential units, followed by use as C1, then it would be impossible to revert to the use as a hostel, and so the site would have no lawful use.
All right. Do you want to comment on that, Mr. Grant?
Not at this stage, no.
Okay, thank you. Before I go on to the appellant's opening, we need to look at the issue of whether the notice can be amended. Well, in fact, it can be amended, but whether it should be amended is more to the point. And can I understand the council's position? I don't quite understand your position at the moment. You seem to be suggesting that the C3 use that's noted on the allegation should be taken out, and just that the material change should be to the current use for the hospital.
So we're running alternative arguments. So our primary position is that the evidence shows on the balance of probability the previous use was lawful use for residential. But we say, if the appellant demonstrates the contrary and either shows a nil use or use as a hostel, then in our submission, the notice should be corrected to delete reference to the previous use, and there would, we say, be no injustice in doing that, because the appellant has fully canvassed in its case what it says was the previous use, namely hostel use. The ground B and C arguments, and indeed the ground A, they all deal with that alternative possibility.
Thank you very much. Mr. Bond, do you want to comment on that?
Yes, our position is that as drafted, the reference to the previous use is factually incorrect. In the event that you came to the same conclusion, our position would be, and we can amplify it through evidence and through submissions in due course, our position would be that to adopt the remedy proposed by the council, in other words, deleting altogether the reference to the previous use, whilst you have the power to do that, we would say that that would result in injustice in this case.
Can you explain the injustice to me, please?
I will do. I was going to say something about it in opening, actually, but in a nutshell, our position is that it is one of those cases where the entire approach by the council, and I don't mean just in terms of the issue of enforcement notices in the first place, but the entire approach in respect of the defence of these appeals is effectively predicated on a loss of housing, which can only arise in circumstances where they've established that the lawful use was C3 residential. But that is something, rather than the learned friend and I arguing about that now, that is probably best addressed, sir, if you agree, in evidence and then in submissions in due course.
Yes, I'd like to hear that. I think that's the best thing. I'll hear the evidence and I have to make my mind up about whether the notice should be amended or not. One of the things that I will want you to address in your cases, Mr. Sutton and Mr. Daines, is whether the change from C1. But let me get this right, is whether the current planning permission and the use that it currently is materially different. I want you to address whether that's a material change of use from what it had permission for in '94 to what it is being used now. So that's something I would like you to address in your evidence.
So yes, and that's plainly a matter that's relevant to the Ground C appeal. And
Yes.
it's a matter that we'll deal with, as I'm sure the council will too.
Thank you.
So if I may just come in there, something which may be relevant to that, and I confess the council has only found it, well, I think yesterday and then this morning, I've had the plans copied, are the plans which are incorporated into the consent at Appendix A, which don't seem to be provided by Mr. Sutton. They were literally handed to me while I was speaking to you. But I think it may be helpful to have those. Of course, Mr. Grant and Mr. Sutton will need to consider them. I don't know if Mr. Sutton, who, as I say, appended the 1994 consent, had them when he did so.
I've certainly seen the 1994 consent.
But not the plans which it appends, I don't think. So the 1994 consent is Appendix 8 to Mr. Sutton's proof.
Right.
But it doesn't include there the plans which are incorporated in that consent. And the council have gone, it's a hard copy file. They've managed to find them and they've been produced this morning to me. And as I say, literally handed to me while I was speaking to you.
I assume you haven't seen those plans, Mr. Grant. Sutton.
So no. So can I just register a general comment, please, which is that we'll explore it again in evidence, but in the course of discussions in respect of the statement of common ground, new matters were raised in terms of the way in which the council put their case. I needn't go into that now, but I will do when I open the case. We had various case law and chapters from Planning Encyclopedia served on us at 8 o'clock last night. And now this morning, and I don't criticise my learned friend if it's just been given to him within the last few minutes, but then this morning, we're told that there's new material that the council want to rely on, which they've extracted from their files. I haven't seen the plans. I suspect Mr. may not either. We'll need to look at them and I'll need to take instructions. But it's a very unfortunate way, if I may say so, of approaching the appeal process to have this flurry of new points and new material emerging at the 11th hour. So I won't say any more about that for the time being, but if the council are seeking to rely on the plans, then obviously they'll need to satisfy you as to how and whether and how they're relevant, and then we would need to consider them, and I'll need to take instructions.
Thank you. I mean, Mr. Grant makes a very good point, doesn't he? That to issue all this late information that could have been found a long time ago and presented to the appellant, so they had it in advance. Can you explain to me why it is important that it should be presented to the inquiry?
Well, sir, if you are intending to consider the extent to which the present use accords with the 1994 permission, my submission is it's not possible to do that without the plans.
So why weren't they presented then before?
So I don't have an explanation for why it's taken as long as it has to find them, save that it was a hard copy file. And as I say, I've literally only just received them. In terms of the other documents, so those were cases which came to light following the way in which the appellant presented its case and its proof of evidence. And you will know, so that it's not unusual for case law to be referred to up to and including closing submissions. I provided it to Mr. Grant last night, and I provided him his request with the paragraphs and propositions of each case referred to. I don't think it's a fair criticism that case law provided before an inquiry opened is late.
Can you tell me what point you're going to be making about these plans? I mean, presumably you believe they're in your favour. What is the point that you're going to be making to the appellants about those plans? How do they favour your case?
So I have yet to have an opportunity to review the plans. As I said, they were handed to me in the course of speaking to you. But as I understand it, the layout differs now from in the plans.
All right. How are you going to distribute these plans?
So I've had my clerk scan them, and I believe that a PDF should now be with the planning officer. And if it is, then I would ask that that be sent to all parties. Mr. Grant and Mr. Sutton, and you have an opportunity to consider them. I will then ask you to admit them, and you can make a ruling on that depending on what Mr. Grant and I say to you.
Yes, you understand that I will have to give the appellants time to what time they need to look at these plans, and it could result in an adjournment sometimes. So on that basis, I will accept them, but you will we'll send them through, and then I'll have a look at them, and I'll hear what Mr. Grant has to say about them. When you receive the plans, Mr. Grant, and you have a break in adjournment or something to consider them, can you then come back to me and let me know what your thoughts on them and on receiving them?
So yes, of course. I think, as I'm sure you'll understand, I don't know, obviously at the moment, how long we'll need, but obviously one of the difficulties of doing these things remotely is that it just takes longer to set up and take instructions, client to Mr. Sutton, to me, and so on. The whole process just takes longer. But as I say, without wanting to sound like a whinger, it is really unsatisfactory that we're getting this on the morning to address a point which Malone and Friend accepts at the very latest. They knew about 4 weeks ago.
Well, I understand that, but the situation is as it is. I think we need to have a consider of it. So, on that basis, if you could send those plans through, and we'll then allow Mr. Grant and Mr. Sutton to consider them. Then what I'd like to do is move on, and I'd like to start with the appellant Soap, please.
I'm so sorry, sir. You're cutting out quite a lot on my...
What I'd like to do is move on to the appellant's opening now. So are you able to send them through?
So I can do, although of course I'm at a slight disadvantage at the moment that there is evidence that the council are proposing to rely upon that I haven't seen yet, which isn't ideal to be opening without being having an understanding of what the evidence is that the council are relying on.
Can I ask, can you be able to send these plans through to Mr. Grant direct?
I think that's either happening as I speak or has already happened.
All right. Well, what I'll do is I'll take a 15-minute break, and then we'll start the closing the opening submission when those plans have come through.
Well, so I won't have been able to take instructions about the plans within 15 minutes, but I'm content to open, and then perhaps we can pause after openings whilst I then seek to take instructions on the plans. But it's bound to take longer than 15 minutes for us all to look at them and to consider them.
Well, I understand that point, Mr. Grant, and as I said earlier, I will give you the time that you need. So don't worry about that. So if you have a look at them, you want to have a consultation with Mr. Sutton, then you will get the time that you need to do that.
Yeah. So can I raise one other matter, which is perhaps the Malone Friend could consider in terms of the virtual setup, as it were, which is that when we get to cross-examination of Mr. Daines, I don't know whether the current intention of the council team is for Mr. Daines to be seen on screen as he is now, But it may be, and you may share this view, that it's difficult enough cross-examining over screens, but where you're looking at a witness whose face you can't see because of the distance they are away, it's even more difficult. So I wonder if my learned friend might just consider, once we get to that evidence, an alternative setup at his end.
I understand. What's being asked is, when you're being cross-examined, can you sit closer to the camera?
So I think you see there's 2 empty seats next to Mr. Daines. We can certainly move him into those empty seats. I hope that would be good enough. It's further away, you can sit where I am, which is face on. I don't think it's possible.
Well, to be perfectly honest, it's acceptable. I can see you, but you're very small on my screen, so it is a little bit difficult. So I would, if it could be made larger, then I would appreciate that.
We will do our best.
Okay, thank you very much.
So in terms of openings, I wonder if it might make, if we're going to open before I've looked at the plans, it may make more sense to have the openings and then to adjourn, rather than to adjourn now and then open and then adjourn again.
Yes, that would be better. So if you could carry on and open, then that would be very useful.
So could you, do you mind if I ask if you or my learned friend just let me know if you're struggling to hear me clearly, because I'm getting a lot of feedback over the system, but I don't know if that's a problem at my end or if it's a problem that others are encountering as well.
I've been able to understand you so far.
Okay. So are you happy for me to proceed then with my opening? Does my learned friend have a copy of it now? And so have you received that now?
It takes a while to get through to me, unfortunately. Let's have a look. It hasn't come through to me yet, but don't worry, I will take notes and I'll slow things down because of that.
So I think in the adjournment, I may log out and try and log back in because of the feedback that I'm getting, but we'll carry on as we are for now, if that's okay.
All right, thank you.
These appeals relate to 24 separate enforcement notices issued on the 17th of January of 2020 concerning 24 units on the first, second and third floors of a block known as 104 to 108 Curtain Road. The issues arising apply in the same way to each enforcement notice. Curtain Road is a well-used road through Shoreditch from Old Street to Liverpool Street Station, 104 to 108 being a 6 to 7 minute walk from Old Street Station and a 10-minute walk from Liverpool Street Station. The area comprises a mix of commercial, office and residential uses, including a number of hotels and other visitor accommodation in this busy part of London. The block is within London's Central Activities Zone, described in the London Plan as the vibrant heart and globally iconic core of London, whose strategic functions include the provision of tourism facilities. The building is laid out over 6 stories, including a lower ground story, though the enforcement notice concern only 3 of the upper floors. At the ground floor is a popular and well-established drinking establishment called the Hoxton Pony Bar, whose opening hours run late into the night and until 2 o'clock in the morning at weekends. The council have enforced against serviced accommodation at first, second and third floors. This type of accommodation is a modern and popular feature of London's visitor infrastructure and is specifically recognised by the Mayor in policy. And you'll see in the footnotes, I refer to London Plan E10. Each unit includes private bathroom and cooking facilities, and services are provided by way of linen and towels, communal washing machines and ironing facilities, and communal parts are regularly cleaned by staff who clean each apartment once guests have checked out. Stays are short, and this was confirmed in discussions between officers and guests at the site visit of the 7th of October 2019, so visits I should say, and the 2nd of January 2020. Guests had specific checkout times, that should say, and as one would expect of this type of accommodation, there were no personal effects decorating or adorning the rooms. The council issued enforcement notices shortly after the second of these visits, alleging a material change of use had taken place from C3 residential use to serviced apartments. Both the officer's report and the reasons contained in the notices relied principally on an in-principle objection based on the loss of housing stock to the stock of serviced apartments. That approach presupposes that the lawful use of each apartment is as a C3 residential dwelling house. That is fundamental to the council's rationale and approach. However, the council's approach is ill-conceived and ill-considered. The appeals are made under grounds B, C, A, F, and G, and I start with ground B. The allegation is incorrect as a matter of fact. There is no issue that the use was and remains as serviced apartments. The issue is the previous use alleged by the council. The notices referring to a change from a C3 residential dwelling, and the council having made clear their position that this was the lawful use. The allegation relies on C3 residential, which is without foundation. There has never been any planning consent for such use, and there has never been any certificate of lawfulness for such use. The council have not provided evidence of such unauthorised use, continuing on an uninterrupted basis over 4 years, such that it became lawful. And for reasons that Mr. Sutton will explain, if there was any intermittent C3 use in any of the units on floors 1 to 3, it's not possible to identify whether this took place and when. The only conclusion which can safely be reached on the evidence is that the lawful use remained hostel use. If the inspector is not satisfied that a change of use to C3 residential took place in respect of a particular apartment, then the hostel use remained the lawful use. The inspector has the power to vary the notices by simply deleting reference to a previous use, and this is the remedy proposed by the council if the inspector accepts the appellant's argument. However, this power should only be exercised where it would not result in injustice. In this case, it would cause injustice to the appellant, since the assertion of a lawful C3 use is at the heart of the council's entire approach, both to the taking of enforcement action and to the conduct of these appeals. It's clear from both the delegated report and the council's written evidence that the loss of housing, which the council claim is the consequence of the use as serviced apartments, is the heart and soul of the council's approach, both to the decision to take action and to the defence of these appeals. I move on to ground C. And so, as you noted in your opening remarks, there's clearly a parasitic relationship between grounds B and C. The lawful use is as a hostel, a consent having been granted in 1994. There is no issue that this was implemented, and the council recognised this as the last lawful use in 2013. And you'll see in the footnotes I refer to an officer reports in the evidence. It is the appellant's case that a change from use as a hostel to use as serviced apartments does not amount to a material change of use, since they are sufficiently similar in character such that one can replace the other without involving a material change. Whilst there is no definition of hostel in planning law, the now cancelled circular of 2005 provides some assistance, including by reference to the case of Panayi. But whilst there is no definitive list of must-have characteristics in order to be treated as a hostel, it is clear that many of the key characteristics of hostels are shared by the serviced apartments in this case. And I provide a short list to illustrate that. First, overnight or short-term accommodation. Second, the presence of shared facilities, in particular laundry facilities. Third, the accommodation of a specific category of people. In this case, you'll see I put in brackets tourists. The servicing of the premises, that's cleaning and the provision of clean linen and towels. the transient nature of occupation, and the provision of self-catering facilities. The irrelevant issue is the character of the use. In this case, there are strong similarities in character between the hostel use and the use of serviced apartments, such that a change from one to the other does not amount to a material change of use. And I turn then to ground A. If the inspector rejects grounds B and C, then the appellant invites a user to grant planning permission for the use of each apartment as a serviced apartment. In considering the ground A appeal, the inspector must have regard to the provisions of the development plan insofar as material, and to any other material considerations. The reasons for issuing the notices disclose 3 objections by the council, although only one of these is given any meaningful airtime in the council's evidence. And I turn to those 3 objections. First and foremost is the in-principle objection to the loss of housing. However, the consequence of the use as serviced apartments is not, we say, loss of C3 housing. Second is the unfathomable suggestion that the use is not fully compatible with surrounding residential land uses. This unusual planning terminology, in particular fully compatible, was rooted in an old policy, DM27, which is recited within the reasons in the notices, and not surprisingly, has not lived on into its successor, which is LP25. Nonetheless, A, the use is in keeping with surrounding uses, as Mr. Sutton's evidence demonstrates, and B, not only is there no evidence or analysis to support this contention, but the council's proof does not say a single word about it, let alone how this even begins to harm the character and function of the area. Third, it suggested that the use has significant impact on the residential amenities of neighbouring occupiers at 4th floor level. This vague objection is barely, if at all, explained and generates but one sentence in the council's evidence. It is once again devoid of any analysis or evidence to support it. Each of the council's objections is without merit. By contrast, there are a number of considerations which support a grant of planning permission, and I list here 3. But first, the demonstrable need for serviced accommodation as part of the visitor infrastructure in London. And I note of all London boroughs, Hackney has the 6th largest projected growth in demand for serviced accommodation up to 2041. Second, the good quality of serviced apartments provided in a clearly suitable location. Third, whilst it's the appellant's case that the fallback is used as a hostel and that there can be no harm when assessed against that fallback, the council's position is that the alternative is the use of each apartment as a self-contained C3 dwelling, reflecting the council's position as to the lawful use. However, each apartment, whilst providing a good standard of serviced apartments, would be clearly substandard as self-contained dwellings. By way of example, all of the units would be very substantially below the minimum space standards. The largest unit is 20.4 square meters, the smallest is 13.67 square meters, and 12 are below 14.5 square meters, and they average 16.26 square meters. And so in the Statement of Common Ground, there's a table which sets out, as agreed, those measurements. None benefit from any private or communal external amenity space. A mirror image application for planning permission for a residential dwelling or a scheme of residential dwellings would have no prospect of success, yet the council are effectively promoting substandard flats in their approach to this case. It became apparent at the 11th hour and 59 minutes through Statement of Common Ground discussions that the council now seeks to suggest that a relevant issue is the lost opportunity for C3 housing, presumably to circumnavigate the unattractive case for 24 substandard flats. The suggestion that this was always part of their case is blatantly not correct, But in any event, and more importantly, it is a point which is again misconceived and without substance. It is the appellant's case that the development in each notice is not in conflict with the development plan overall, but even if it was, that is outweighed by a compelling collection of material considerations. And in our submission, there's an overwhelming case in favour of grants of planning permission. And I deal then very briefly with grounds F and G. Ground F needs little ventilation, since it is parasitic in this case on the success of ground A. And so far as ground G is concerned, that seeks a longer compliance period, not least so that existing bookings for the 2022 summer period can be honoured. And so that's all I say by way of opening.
Thank you. You did just break up in the last moment, but I think you're just closing, so you don't need to repeat it. Thank you very much, Mr. Grant. Then if I would just say also that I have received your opening now, and I've received the plans from the council. Have you received the plans from the council?
I haven't yet, but I don't know whether my instructing solicitor or Mr. Sutton may have done, but I haven't seen them yet.
Okay.
Can I ask Mr. Sutton, perhaps, sir, if you don't mind, if he can perhaps indicate, or Ms. Hereward, whether they've received them?
Please do.
They're on the screen. I wonder if one of them might just pipe up and indicate. Ms. Hereward's on
the microphone is off, Ms. Hereward.
Right. I've now received them and I'll send them on to you.
Right.
Thank you very much.
Thank you very much. Thank you. Then I'd ask Mr. Friesen if you'd like to make the opening statement on behalf of the council, please.
Yes, so just for your note, it's Streeton, Street E for Echo, in November.
Right.
I've asked for a written version of this to be sent round. So these appeals concern 24 separate enforcement notices served in relation to 24 self-contained units used unlawfully as service departments on the first and third floors of 104 to 108 Curtin Road, London, EC2A3AH, which together comprise the site. There does not appear to be any dispute that a breach of planning control is taking place, and certainly it's not contended that the lawful use of the site is as 24 self-contained service apartments. Nevertheless, the appellant appeals on grounds B and C, as well as A, F, and G, with ground D abandoned by the appellant in Mr. Sutton's proof of evidence. In terms of the site's lawful use, so I'd just like to add to my written opening here, the appellant's argument of a fallback or lawful use as a hostel is not included in their grounds of appeal. It is a point raised in their proof of evidence to which the council has had to respond at the inquiry. That then would lead me on to my paragraph 2. The burden of proof in an appeal under section 174 is on the appellant. The standard is the balance of probabilities. The council's case is that on the balance of probabilities, the lawful use of the site before its use as 24 service departments was as 24 self-contained C3 dwelling houses. This emerges from the documents relating to previous planning applications, from council tax records, and from statements made on the appellant's behalf. The appellant does not accept this. It argues that the lawful use of the site is as a hostel in accordance with Planning Commission reference South 3694 FP, the 1994 Commission. Given the clear evidence of an intermediate residential use, it seems highly unlikely that the lawful use of the site could be as a hostel. And I add here, sir, especially if it does not accord with the plans of the Commission relied upon. Rather, if the residential use of the units did not accrue immunity from enforcement action under section 171B2 of the 1990 Act, then the effect of there having been a change of use from hostel to C3 residential, and then from C3 residential to C1 service departments, is that the site would have a nil use, i.e. would have no lawful use. See Cynon Valley and Newland. Turning to ground B, if the council's primary submission that on the balance of probabilities the lawful use of the site as 24 residential is accepted, then the appeal on ground B must fail. In the alternative, if the lawful use of the site is either nil or as a hostel, then the enforcement notices should be corrected by deleting reference to residential use. There's no dispute that you have the power to do this. It would not cause injustice to the appellant. The appellant has been aware that this is the council's position since the council served its statement of case. It has had the opportunity fully to set out its position in relation to what it says was the previous lawful use, and has argued its case on this basis and on all grounds. The only substantive reason given by the appellant as to why the notice should not be corrected concerns expediency. Expediency is a matter for the council alone. It is a matter which there is no jurisdiction to consider on appeal, see Britannia Assets. Suffice to say, the council regards it as expedient to continue to resist this appeal on all grounds, whatever the lawful use of the site. The appeals on ground B should be dismissed with a correction made to the notice if necessary. Turning to ground C, if the lawful use of the site is as 24 residential apartments or is nil, then ground C cannot possibly succeed. In the unlikely event that the appellant is taken to have demonstrated on the balance of probability that the lawful use of the site is as a hostel, this ground still fails. There is a material difference in the character of the use of the land as a hostel, which is sui generis, and C1 serviced apartments. The nature of the uses are different, they meet different needs and have different planning consequences. The appeals on ground C should be dismissed. Turning to ground A, whatever the lawful use of the site, but especially if its lawful use is as 24 residential units or is nil, development consisting of a change in its use to use as 24 serviced apartments does not accord with the development plan read as a whole. It does not accord with policy H8 of the London Plan and policies LP2, LP12, LP24 if the lawful use is as residential units, and LP25 of the Hackney Local Plan. It does not accord with the strategic priority given to the delivery of housing in the local plan. Overall, regardless of whether the previous lawful use of the site is as residential units, is nil, or is as a hostel, a change of use to use as serviced apartments does not accord with the development plan read as a whole, although the previous lawful use may be relevant to the extent of the departure. There is therefore a statutory presumption against the grant of planning permission, see section 38.6. Nor does the change of use to serviced apartments accord with the policies in the National Planning Policy Framework, which make clear that decision-taking should be genuinely plan-led. There are no other material considerations which would outweigh the identified conflict with the development plan, and the appeals on ground A should be dismissed. On ground F, as the appellant recognises, ground F stands and falls with ground A. And finally, on ground G, the enforcement notice require only that the unlawful use cease. Given the short-term nature of the lettings, time for compliance with the notice is reasonable. The appellant's argument on ground G is that it should, for a period of 12 months, be permitted to continue to make profit from an unlawful use, even if it has been found that planning permission for that use should be refused. That's an untenable approach. It has the effect of delaying the use of the site for a purpose which accords with the development plan. And for those reasons, sir, the council respectfully requests that the appeals be dismissed.
Thank you very much. I would agree with you that it's the appellant to making up their case, for them to prove their case. There's also the situation that it's generally accepted that the appellant's case is accepted unless it's ambiguous or the council can cast doubt on that case, and that's what I would be looking for.
Yes, sir, of course that's right, but we have no ground D anymore. The appellant makes no case, say with reference to the 94 permission.
But yeah, it doesn't matter whether there's a ground D. In this case, there's a ground B, and the previous use is clearly relevant to that use, and we have to accept what the appellant says unless it's ambiguous or you can stand on it. It doesn't matter that there's not a ground D.
No, sir, but what I mean is that there's no evidence from the appellant. The appellant refers to the 94 permission, but there has been no explanation, no witness statement from anyone within the appellant as to how the property was used during the 11 years that it owned it.
Well, I will be asking some question on that, but we have the 1994 planning permission.
Yes, sir, and I'll explore that in evidence.
All right. Well, as long as you understand the situation, that it's either got to be ambiguous or you've got to cast doubt, then I'll carry on with that. What I'm going to do is take a break now. The plans have come through to me. Would 15 minutes be acceptable?
So I want to avoid having to come back in 15 minutes and ask for more time. I think realistically, by the time I've printed them off, looked at them myself, discussed them with Mr. Sutton and so on, it's going to be longer than that. Okay. Can I ask for half an hour? And I hope that that's long enough, but without having seen the documents, it's very hard to...
No, well, if you need more time, then tell me. Half an hour is acceptable. So it's 10:55. If we can meet at 11:25, the inquiry will resume at the 11:25. Thank you.
Thank you, sir. Just two administrative points. I haven't received Learner Friends opening in writing. He may have sent it, but if not, I wonder if it could be sent through. I was scribbling away anyway. And second, just received now. Thank you very much. And second, sir, please don't be alarmed, please, if you see me having logged off, because I'm going to log back in to see if I can improve the connection at my end.
All right. Thank you very much. Okay, the inquiry is adjourned.
Many thanks. a factual matter, is your advice to the inspector that the inspector can be satisfied on the evidence that the council are correct in saying in the allegation that the change of use was from C3 residential use?
No, that's incorrect.
Can we turn please into your appendices at Appendix 6?
Yes, I have that.
And just so that we understand clearly the council's position, we see there, don't we, a sequence of correspondence between the council solicitor and council planning officers and Miss Hereward, who is the solicitor acting for the appellant.
Yes, that's right.
And if you turn forward, please, into the exchange of emails. And I think if you turn forward about 6 pages, you'll see an email dated the 24th of February 2021 from Patrick O'Connor.
Yes, I have that.
And just pausing there, Mr. O'Connor, I think, is the enforcement team leader who signed the enforcement notices, isn't he?
Yes.
And do we see in the email sent by Mr. O'Connor to Ms. Hereward, in the substantive paragraph of that email, he sets out the council's position that the lawful use of the properties is C3 residential?
Yes, that's what it says.
Now, as a starting point, at least, what was the last use covering floors 1 to 3 in the building, the last use to have been granted planning permission?
It's the 1994 permission, reference South 3694 FP, which is set out in my section 4 on the planning history.
Yeah. And so far as that consent is concerned, I think that there was a reference, wasn't there, in the either in the description of development or on the body of the document to various drawings. Yes.
Yes.
But then, so far as the conditions are concerned, did any of the conditions specifically identify particular drawings?
No.
And I think I can, hopefully with no friends agreement, just lead you on this. Condition 3, I think, referred to drawings to be agreed between the council and the applicant.
That is correct.
Yeah. Now, so far as that consent is concerned, has there been any superseding grant of planning permission in respect of the use of these floors in the building?
No, there has not.
And has there been any certificate of lawfulness in respect of other uses within those floors?
No, there has not.
And can you turn forward in your appendices, please, to Appendix 9?
Yes, I have that.
And that is the officer's report for a planning application submitted in 2013. Reference 0069. Yeah.
Yes, I have that.
And we can see, can't we, on the first page of that report, the proposal was for the recladding of existing mansard roof and the erection of a 2-storey roof extension above to form 2-bedroom maisonettes. Do you see that?
Yes, I see that.
And if you look at the next page, please, which is the site description.
Yeah. Yes, I have that.
We see there, don't we, that the last known lawful use of floors 1 to 4 was as a hostel sui generis.
Yes, that is correct.
And it refers, doesn't it, to the application form referring to the upper floors as being residential C3 use. Do you see that? 28 studio flats.
I see that, yes.
I'm just pausing there. Can I ask you, please, and I'm going to try not to take you to hundreds of documents, given that we're doing things virtually, but can I ask you, please, just to have a look at the council's appendices at Appendix 12. So can I check that you received received a further copy of the council's proof which numbered the appendices, which enables us to refer to them by number during the evidence? So I think you may be on mute.
Thank you. I'm putting it on mute because of the interruptions, and as I'm hoping not to do that. I haven't received that, so if you can, I've read through all the documents. So if you can just tell me which one it refers to, I can probably find it because I've got all the appendices here. But
So it's now Appendix 12, and it's the delegated report, reference 2013 sorry, it is the application form 0069, which is now Appendix 14 of the council's appendices.
yeah, I've got that. Thank you. Yeah.
Thank you very much. And I think if you turn forward in the document, Mr. Sutton, to the 4th page.
Yes.
And if you have a look, please, at box 18.
Yes. Yep.
First of all, that refers, doesn't it, to residential units?
It does. Yes, it gives you the option for the different types of residential units.
And the box that is ticked, I think, in terms of the existing position is, it says houses, which I think we can all agree must have been an error. Houses 28.
Yes, correct.
And in terms of the reference to residential units, does that specify a type of residential unit within the descriptive terms of the box? In other words, does it indicate C3 residential units?
Sorry, could you just repeat the question again?
Yeah. Does it indicate where the box is headed residential units?
Yes.
Does your proposal include the gain or loss of residential units? I mean, first of all, does it indicate what type of residential unit?
It does. It gives a different options, either flats, masonettes, bedsit studios.
All right. We can put that to one side. Can we go back, please, to your appendices and Appendix 10?
Yes, I have that.
And this is the report number application 2670, which was a related application, wasn't it? For additional stories at the 5th and 6th floor levels. Yeah?
Mm-hmm. Yes, I have that.
And do you see again in the site description box a reference that it would appear to be in use as residential on the upper floors, although this appears to be unauthorized? You see that?
I see that, yes.
And then if you turn forward in the document, please, to about 4 or 5 pages, there's a section under the subheading Policy and Strategy.
Mm-hmm. Yes, I have that.
And can you see there, the 3rd paragraph down, which begins with the word however?
Yes.
However, given the use on the 1st to 4th floors in residential or hostel use.
Hostel use, yes.
Yeah. Yeah.
Yes, I see that.
And Mr. Sutton, in respect of the reports for either of those applications, is there any suggestion from either report that any of the planning officers dealing with those applications would have needed to visit floors 1 to 3 and inspect what was happening on those floors?
No, there's nothing in the reports which just suggests they did that.
Yeah. Okay. And can you turn forward now, please, in your appendices to a document that you've included as a Appendix 11,
Yes, this is the pre-app advice from March 2018.
yeah, thank you very much. And if you turn forward, please, to the third page under the heading Site Description and Background.
Yep. Yes.
Does it say there in the third line onwards, it's unclear what the lawful use of the upper floors is, although at present it appears the upper floors appear in residential use.
Yes.
And then in the following paragraph under the heading Loss of Residential Use, do we understand there the basis for that officer saying that it appears to be in residential use?
We do. It's reference to the council tax records.
Yeah. And again, so far as that pre-app is concerned, is there any suggestion or would you have expected the officers to have gone to floors 1 to 3 and to have inspected internally or otherwise those units?
I wouldn't necessarily expect them to have done so, and there's certainly no evidence that they did.
No. And can we talk about the council tax position briefly, please? I think, as we understand it, the council's position in respect of council tax is that is a reliance on the fact that each unit was registered for council tax, and that I think is that your understanding as well of the
yes,
the reliance on it. Now, so far as that is concerned, at a time when it's agreed by all parties, when the notices were issued and in the period leading up to the notices, that the units were in use as service departments, were the units registered for council tax during that period, or was the were they registered for business rates or some other?
No, they were registered for council tax purposes. I mean, in my experience of submitting certificates of lawfulness in respect to residential uses, I would never rely on council tax evidence. It's not, in my experience or opinion, a good indicator of reliability as to whether a material change of use has happened or not.
And what does the fact that even when they're being used as service departments, and we know, don't we, that the council were visiting in October 2019 and then going forward into January of 2020, what do you say the inspector should take away from the fact that that even then, when the use was as service departments and all agree it was, the units were registered for council tax?
I think the simple point is that no weight can be attached at all on the reliance of the council tax records as being any indicator that there's been a material change of use at any point to residential use for any of the 24 apartments.
Yeah. You're aware of the discussions, and I think it's been ventilated, at least in your written evidence as well, about whether or not it would be just or unjust for the inspector to delete a reference to the previous use within the notices. In your view, would it be just or unjust?
It would be wholly unjust. I mean, the issue goes to the heart, absolutely to the heart of the council's case. So yes, there is clear injustice if the inspector was to delete that reference.
Now, that the council say, don't they, we heard in opening this morning, that what you're really saying in making that point is you're inviting the inspector to go into the question of expediency. That, I think, is the council's response to that. Is that what you're doing, or does it go beyond expediency?
It goes well. It goes well beyond expediency. I mean, as you say, it goes to the heart of the council's case. I think it was described in your opening quite well in terms of its heart and soul of the case. I think if the inspector was to effectively delete that reference from the enforcement notice, then effectively that's the entire basis on which the enforcement notices were issued, and the appellant would effectively be arguing a different case.
Yeah, I mean, you know, obviously, in respect of each notice, there are two reasons for issue in respect of each notice, and those have travelled forward into the council's objections during the appeal process in respect of ground A. Supposing the inspector came to the conclusion that there was no substance to the second reason for issuing the notices and the objections contained there, supposing he concluded no substance in that, what would be left as the sole basis of the council's resistance to the application arising under ground A?
Well, effectively compatibility with the surrounding area.
No, just listen to the question.
Oh, sorry, beg your pardon.
Supposing the inspector came to the conclusion that in respect of the second reason for issuing the notice,
second, yes.
there was no substance to it.
Yes.
Supposing he came to that conclusion, what would that leave as being the only objection relied upon by the council?
Whether or not there is a loss of housing.
Yeah. And in order for the inspector to conclude that there was a loss of housing, we'll come onto this again in a few minutes, but in order for the inspector to conclude there was a loss of housing, to what extent does that, in your view, hinge on the inspector's view as to whether or not there is a lawful C3 residential use?
That's fundamental.
Yeah. So again, just to wrap this point up, if the inspector concluded there was nothing in the second reason for issuing the notices as defended at these appeals, would it be just or unjust to delete the reference to the previous use and for the appellant to then have to fight the appeals on the basis of loss of housing solely?
Sorry, just repeat the question again.
If the inspector took the view there was nothing in the second reason for issuing the notice and the objections arising out of it,
yes,
leaving only the objection pursued from reason for issue 1, the loss of housing. Yes, if he took that view, then how just or unjust would it be for the appellant to have to continue fighting these appeals if the council had been unable to rely on the previous residential use in the allegation?
It would be unjust.
Now, in the opening for the appellant this morning, you heard me say, and to rather shift the onus to you, I indicated that you would explain it in due course. You heard me say that you would explain that if there was any intermittent C3 use in any of the units on floor 1 to 3, it's not possible to identify whether this took place and when. Did you recall that part of the opening this morning?
That's correct, yes.
And can I ask you please just to amplify on that and to explain the position to the inspector?
Yes, certainly. I mean, the appellant purchased the property. They purchased it obviously with the hostile permission. There were various tenancies in place. Those tenancies were, to all extents and purposes, there was certainly a degree of what was at the time short-term letting, which now would be classed as an Airbnb type use. That was carried out over throughout the number of units. The appellant effectively allowed those tenants to get on with it because the rent was coming in. As Airbnb generally became more popular, as it got to sort of 2016, 2017, then the appellant decided to introduce short-term Airbnb letting themselves. And that was a gradual process. It didn't start all at once in terms of all of the units at a single time. It was a process that started with 1 or 2 units and then carried on and as more units became available. But it's entirely unclear, because it was undertaken by others, exactly how those units were used and whether there was any material change of use to residential at all. So it's our position that there is no clear evidence of any material change of use throughout the period to residential use.
So I have my hand up. I don't know if you can see that. I think you're on mute again, sir. Sorry.
I am back again. Yes. When I say put your hand up, there is a little icon on the screen that you can press that puts the hand up.
I think I have both, sir.
Oh, do you?
It's not working because I certainly clicked the button.
Right. But what would you like to say?
Well, just that there was reference there to tenancy agreements and to a number of other documents in history, which I didn't find myself in Mr. Sutton's proof. And if those are being relied on, I'd obviously like to see them and any factual evidence to support it, because that's the first time I've heard any of that. It's entirely new.
Mr. Grant.
I think what Mr. Sutton said, I mean, he can answer himself, but I think what he said was that there were tenancies in place with short-term lettings, and which now would be classed as Airbnb. But I'm happy, of course, for him to answer the question as to whether or not there are documents available or not.
Mr. Sutton.
I would have to take advice from the client on that. I don't have them to hand.
Right. So when you were referring to tenancies, you weren't referring to documents. You were just referring to the tenancy itself. So.
Yes.
All right. Do you understand that it wasn't referring to a tenancy document? It was just referring to the tenancy of the property.
Well, so I mean, I just wish to understand whether he means tenancy of rooms or tenancy of the building as a whole, because as I say, I haven't heard any of this before, and I just answer. I mean, I hear what Mr. Sutton says. He says there were tenancies, they were Airbnb style, but I just don't understand what the evidence relied on for that is. I've certainly never seen any, and then this is the first time it's being raised.
Well, so with respect to Millennium Friend, isn't the appropriate time for Millennium Friend to ask Mr. Sutton about that in cross-examination? Rather than now, we're certainly not. If we were going to be relying on documents, we'd have produced them in the normal way and at the usual proper time. So, of course, as the Millennium Friend is at liberty to ask about that in cross-examination, but I'm not sure that now is the appropriate time.
All right. Well,
we're certainly not intending to be producing rabbits out of hats.
No.
So it is a rabbit out of a hat. None of this is in the proof of evidence.
Are there any tenancy agreements available?
I'm not aware. I'd have to take instruction.
Let me just see what was said. I think again, if there is anything you want to produce, then to answer this question, then I'm happy for you to produce it to answer the question. But I think if you want to explore this further, then if you can do it in the cross-examination, please carry on.
Yes, sir.
Yeah, thank you very much. Can we move then, please, to ground C? And first of all, clarification, if we need it, is the appellant's case on ground C about whether or not a change from a C3 residential flat to a serviced apartment would be a material change of use?
No, it's not.
And I think we're agreed, I think set out in the statement of common ground, the issue of arising under ground C is whether or not a change from a hostel use to serviced apartments would be material. That's the issue I think that you're identifying and relying on for ground C. Is that
That
right?
is correct, yes.
And now if you can turn please into your proof to section 6 and paragraph 6.6.
Mm-hmm.
And you refer there to the courts in the Westminster and British Waterways Board, and you set out there 2 questions about the character of the use and the range of uses sufficiently similar in character to be capable of replacing the established use without involving a material change. Now, so far as hostel use on the one hand and the serviced apartments on the other hand, what do you say, and we'll go into the detail of it in a second, but what do you say about whether or not those are sufficiently similar in character for one to replace the other without involving a material change?
That is the case, that they are sufficiently similar in character as to therefore not to be a material change of use between the two.
And then if we just go up slightly on the page in your proof to paragraph 6.4, you set out there, don't you, a series of bullet points that you identify as the similarities. Perhaps there are 6 of them. Perhaps you would just very quickly read those out, please.
Yes, this is my paragraph 6.4. So in terms of the similarities, I mean, they both have short durations of stay, no form of care provided or any hotel facilities, generally a small room size, a rapidly changing transient occupancy, a lack of on-site car parking, and are often centrally located in cities or near heavily touristed areas.
Thank you. And just before we leave that topic, can we turn forward, please, in the council's appendices to what we now know as Appendix 16. So you'll have it as unnumbered, but as the circular, albeit now cancelled, but the circular from March of 2005.
Yes.
And can I ask you please to turn to the section which I think is identified by the council, which is the section on page 9, beginning at paragraph 60 under the heading hostels.
Yes, I have that.
And can I with you please just have a look at paragraph 61 and 62 and identify the extent to which the range of factors identified apply to the serviced accommodation in each of the 24 units. So first of all, looking at paragraph 61, overnight or short-term accommodation, does that apply or not apply?
That applies.
There's a reference to may be supervised. I don't think there's any suggestion of supervision here, is there?
No.
Some may provide facilities for self-catering. Is that the case here?
Yes.
And then we see further down the paragraph, occasionally hostels are used to provide longer term accommodation, so it's not solely short term.
No.
And then if we look at the series of factors in paragraph 62, identified in the case of Panayi. Now, first of all, just reading paragraph 62 and reminding yourself of what Panayi said. Was the court saying there that every factor identified had to be present in order for something to be a hostel?
No, it doesn't say that.
And just looking at the list of factors, the presence of dormitories and or communal or shared facilities, well, are there any communal or shared facilities?
Yes, there are, in terms of the laundry facilities.
Yeah. And then the use of the premises in accommodating specific categories of people. Again, is each apartment aimed at any specific category of people?
Yeah, it is very much tourists.
And whether the premises are supervised and or serviced and or supervised, no supervision. I think it's all agreed that they're service, correct?
It is, yeah, they are, yes.
Not a situation, is it, where payment is by the local authority? What about payment on a nightly basis?
Yes.
And what about residents being transient? Not in the sense that they're placed on a waiting list, but what about transient in the wider sense?
Certainly transient in the wider sense, in terms of tourists who are coming, staying for a short period of time and then leaving, being replaced by others that are staying for a short period of time and then leaving.
And then the final two bullet points refer to the requirements and the display of various fire notices and so on and so forth. I mean, are you able to help on that or not?
I mean, yes. I mean, there are various notices up on the premises. So obviously there are requirements for safety certificates. So yes, the property has those as well.
I mean, if we just have a look quickly in your photographs, which are in your appendices at Appendix 3. I mean, this isn't, if we go forward into the corridor photographs, do you see about 4 pages in?
Yep.
I mean, I'm not sure if we see here fire safety certificates, do we, in these photographs? What do we see, though? The photographs of the corridor with a door at the end.
Yeah, I mean, you can see no smoking signs, fire exit sign above at the end of the corridor.
Okay.
Yeah.
Good. Can we then move on, please, to ground A? And just to remind ourselves, through ground A, planning permission is sought, isn't it, in respect of each apartment, the subject of each notice, for use as a service department, as per the allegation. Is that correct?
Yes, that's correct.
And just so by way of a starting plan, starting point, the development plan. First of all, a couple of general principles in respect of the approach to the development plan. Does any breach with a development plan policy mean that the development plan is conflicted overall?
No, not necessarily. It's possible for restrictive policies to effectively pull in different ways, but it doesn't necessarily mean that just because you're in necessarily contrary to one policy that you're in breach of the development plan as a whole.
Yeah, I mean, you refer there to restrictive policies, and I think in your proof you refer to the Cornwall Corbett case that Learning Friend obviously will be very familiar with. But even if there's a breach of a highly restrictive policy in a development plan, does that necessarily mean that the plan is conflicted overall?
No.
And looking then, please, at the 3 issues identified within the 2 reasons for issuing the notice and which are taken forward as objections in respect of ground A. So first of all, the in principle loss of housing. Secondly, the harm to the character and function of the area. And third, the amenity of neighbouring occupiers at 4th floor level. So let's look at those one by one, please. First of all, the loss of housing. Now, we've had discussions already, of course, about whether or not C3 residential use, in your view, had become the lawful use, or whether there was evidence to demonstrate that. But with that in mind, would a planning permission in this case for use as a service department, would the consequence of that be the loss of housing?
No, it would not. No, we don't accept there is any lawful use for housing on the site.
Thank you. And can we just have a quick look, please, together at the relevant policies? And can we start with, well, let's look at policy H8 in the London plan. And so you have that, I think, copied within the council's appendices. We've also got the London plan as a core document now.
I've got it. Thank you very much.
Thank you.
Yes, I have that.
And so far as H8, I don't think we need to dwell on it, do we? So far as H8, it's capital A that is relevant, isn't it? The loss of existing housing.
Yes.
Replaced by new housing, etc. And your position, I think, just as you've identified, is that there isn't a loss of existing housing, therefore no conflict with H8. I think, is that your position?
There is no loss of existing housing, no.
And can we then look, please, at policy LP24, which is the second policy in the development plan, this time in the local plan, which deals with the loss of housing. And again, sir, you ought to find that within the appendices, but I won't give you the appendix number, obviously, because I know you don't have that.
I'm going to ask in the next break if the appendices could be sent through to me, because it will make it a lot easier. So could I have that, please?
So I'll also give you the references then as we go along. So for your note in the meantime, you've got a note of that. So this is Appendix 10, as it's now labelled, and it's policy LP24.
Yes, I have it.
Now, so far as policy 24 is concerned, if we look at capital letter A, we see there the change of use of land or building involving the loss of residential floor space will be resisted. And again, so far as your position is concerned, would the change of use result in the loss of residential floor space?
It would not.
But then there are a series of provisos, aren't there, that are set out in the policy?
Yes, there are.
And it said will only be permitted where at least one of the following conditions are met. See that?
Yes, I see that.
And there are then 6 conditions set out. So far as those 6 conditions, are any of those 6 conditions in your view met?
Yes, the Roman numeral 1 is unequivocally met, and I also think that 6 is met as well. So, I mean, the policy requires only one of the conditions to be met. I say that we meet 2.
Yeah, and so far as little 1 is concerned, no longer suitable for residential use and inappropriate to re-provide residential accommodation. I mean, can you just expand on why you say that that condition bites in this case?
Yes, I mean, the simple point is that we have 24 individual enforcement notices. All of those individual apartments, which are the subject of individual enforcement notices, all of them fall well below minimum space standards. Those units, if a planning application was submitted for those units, it would fail on a number of grounds, design grounds, both in terms of space standards, being single aspect, lack of amenity space. So it would, yes, so it is simply not suitable for a residential use, each of the individual apartments.
Thank you. And then you referred to little Roman numeral 6 as well at the end of this
Yes, I think the site being located within the central activity zone, I think it's fair to say that visitor accommodation can be classed as effectively essential infrastructure for which there is clearly a demonstrable need, and that need is set out in the London Plan. So I think room renewal 6 applies as well.
And what about, I mean, there's a second part, isn't there, of 6, which refers to that it can only be provided by the loss of existing residential floor space. I mean, as you understand it, is that a reference to within the borough as a whole or within the building? How do you read that?
I think it's simply in the building. Are you talking about the need element?
No, second part of little Roman numeral 6, and it can only be provided by the loss of existing residential floor space. You see that?
Yes, I see that.
And what do you say about that?
Well, there's no loss of existing residential floor space on our site.
Yeah, but what if there was? Remember, these are the provisos, aren't they, where there's a loss of housing. So if the inspector took the view that there was a loss of existing residential floor space on site, how do you read this limb of the policy in terms of the loss of existing residential floor space? Is that site specific or borough specific?
I think it's site specific.
All right. Good. So those are the policies in respect of the loss of housing. Can we then look, please, at the second objection, which is harming the character and function of the area? And can we just have a look together, please, at the council's proof of evidence briefly? And can I ask you to turn to section 4?
Yes, I have that.
Now, section 4 lists, doesn't it, the policies that the council rely upon from the London Plan and the local plan. And H8 and LP24, we've visited those already in respect of the loss of housing. LP25 deals with visitor accommodation. LP2, development and amenity. So can we have a look first, please, at LP2, which again, say you have in the council's appendices, and that is numbered Appendix 9.
Yes, I have that.
I have it.
Thank you. And LP2, we see at A, all new development must be appropriate to its location. And then there's a reference, isn't there, to the amenity of occupiers and neighbours, and we'll come on to amenity in a moment. Appropriate to its location. And what do you say about whether or not serviced apartments in this block are appropriate to their location?
I don't think they're wholly appropriate to the location. The appeal site is located within the central activity zone, which is an appropriate location for visitor accommodation. Indeed, it's where the London Plan directs visitor accommodation. It's even within the commercial core of the Tech City Fringe opportunity area in which it lies. The character of that part of Curtain Road is predominantly commercial with a mix of uses. Obviously, there is the Hoxton Pony directly underneath on the ground floor and basement. That aside, there are numerous other commercial, restaurant, drinking establishments, hotels in the immediate locality.
Yeah. Bear with me just a moment, please. And can you have a quick look, please, at the appendix 10 of your appendices on this point?
Yes, I have that.
And this tells us something, doesn't it? In the second page, under the heading Site Description, tells us something about the surrounding area in 2013. What does it say?
It says surrounding area is a mixture of uses with predominantly restaurant, bars and retail at ground floor, office or residential on floors above. Located close proximity to Shoreditch High Street, Overground, Liverpool Street, Old Street Stations, a short walk away.
Yeah. And then can you just turn forward into Appendix 11? That's the pre-app letter.
Yes, I have that.
And the third page under the heading Site Description and Background.
Yes.
Halfway down the page, the paragraph, sorry, there's a sentence beginning the surrounding area. And what did the council officer say there about the surrounding area?
They describe it as surrounding area comprises of a mix of commercial, retail, evening and nighttime economy uses at ground floor level, with uses on upper floors predominantly in commercial office use.
Thank you. And can you take up, please, the statements of common ground, which is now agreed?
Yes.
And can you turn forward in the statement of common ground to paragraph 5.9?
Yes.
And perhaps you tell us what's agreed at 5.9.
So the 5.99 says this part of Hoxton Shoreditch comprises a significant mix of commercial, residential and office uses. In the vicinity of the site, a number of hotels and visitor accommodation can be found, which are reflective of the diverse nature of Hoxton and its proximity to central London and key transport nodes.
Thank you. And then in your proof of evidence, you have a section, don't you, which we can find at paragraph 3.10 on page 9.
Yes.
And you refer there to the mix of uses in the area. And then you list, don't you, hotels and serviced accommodation, which are within around 200 metres of the appeal site. And you list, I think, 8 different offerings. Yeah?
Yes, I do.
And have you seen any analysis from the local authority in their proof of evidence or anywhere else to indicate that having a serviced apartment within this block and 24 service apartments within this block would harm the character and function of the area?
No, not at all.
Would it harm the character and function of the area?
No, it's entirely in keeping.
Yeah. Can you just pick up, please, the London plan? And can I ask you, please, to turn, first of all, to page 70.
Yes.
And with keep that open, and then can you open the statement of common ground, please, and go to section 7, policies.
Yep.
And you'll see there under the policy section, under the heading London Plan, the council consider only H8 to be relevant, the appellant considers the following to be relevant, and then a reference to SD4. Do you see that?
I do.
So that's a policy that you, on behalf of the appellant, consider to be relevant. The council say is irrelevant. And let's have a look, please, at SD4 on page 70.
Yeah.
And that that is the policy that relates, isn't it, to the central activity zone.
It is, yes, in which the site lies.
And this, yeah, we'll come to that in just a moment, so you can show us that. But if you have a look, first of all, at the supporting text to the policy at 2.4.1.
Yep.
You see there, the CAS is the vibrant heart and globally iconic core of London. Yeah.
Yes, I see that.
And that I think, although in the supporting text, that's taken directly, isn't it, from the glossary definitions that are within at the rear of the London plan.
Yep.
Yep. And perhaps, actually, if you don't mind turning to the definition on page 500.
Yeah.
And do you see there the second sentence? The CAS contains a broad range of functions with London-wide international significance, including government, business, culture, research and education, retailing, tourism, transport and places of worship. And then if we turn back to where we were on page 72, the supporting text of the policy, do you see paragraph 2.44?
Yes, I do.
And do you see there a list of the strategic functions of the CAS?
Yeah.
Which include but not necessarily limited to. And what is the strategic function identified at Roman numeral? It's not Roman numeral at all, actually. It's little j.
It says tourism facilities, including hotels and conference centres.
Yeah. And then can you turn forward, please, in the supporting text to the following page, 2.4.11?
Yeah. Yes, I have that.
And again, just the first sentence of that text, what does that tell us about tourism within the CAS?
It's a defining feature.
Yeah. And then you were rushing ahead a moment ago to explain how we can the basis for saying that the site's within the CAS. I don't think there's any dispute about it. But if you turn forward to page 77, figure 2.16.
Yep. Yes.
We see there, don't we, on this diagram, a number of numbered clusters. You see
Yes,
that?
I do.
And which is the number within which the appeal sites lie?
It's 4.
Thank you. And if we look at the shading, 4 is shaded in blue. And if we look at the key at the bottom, what does that shading tell us? The key at the bottom of the page.
Yes. As specialist clusters, it's arts, culture and entertainment.
And if we just have a look then on the facing in fact, no, I don't think we need to do. Well, if you look at the facing page, it refers to opportunity areas, doesn't it?
Yes.
And it refers to opportunity area 4. You see that, which is City Fringe and Tech City.
Yep.
And we can see that, can't we, in the northeast corner of the CAS diagram?
Yep.
And it is the appeal site within that opportunity area, or is it outside that opportunity area?
It is within the opportunity area.
Yeah. Right. Thank you. We can put that away. We are going to return to it in a few minutes, but we can put that away for the moment. So just drawing that all together, please, in relation to this second objection, what do you say about the suggestion that the the use as serviced apartment would harm the character and function of the area. Any basis to it or not?
No basis at all. It's wholly in keeping.
Yeah. Third objection then, please, amenity. And the enforcement notices refer specifically, don't they, to neighbouring occupiers at 4th floor. Now, unless or until we hear anything different, I mean, do you interpret 4th floor to mean 4th floor of this building or some other building?
This building.
And if you can open, please, the council's proof of evidence. And can you turn forward in the proof to paragraph 7.32 on, not paginated, but 7.32.
Yes.
And it's the final sentence here. The loss of the 24 residential units is contrary to this policy, as the transient nature of occupation of the property may result in significant adverse impacts on the residential amenity of neighbouring occupiers due to elevated levels of noise and disturbance, which one would not typically expect from more permanent residential occupiers. Do you see that?
Yes, I do.
Now, so far as the council's case on amenity, other than that sentence, I mean, do you see the council amplifying their case anywhere else, or is that the sentence that that sets out their position?
That's it.
Yeah. First of all, I mean, do you agree or disagree that the loss of 24 residential units and the replacement, in effect, by 24 serviced apartments would result in significant adverse impact on the residential amenity? Presumably they're talking about at the 4th floor.
Mm-hmm.
Agree or disagree? Or have I asked you that already?
I don't agree that the loss of residential and replacement with serviced accommodation would have an adverse impact on the residential amenity of 4th floor occupiers.
No, I mean, have you seen any evidence or analysis to support that contention?
No, not at all.
I mean, just looking at it a little bit, I mean, the difference between people saying on a short-term basis and more permanent occupiers, I mean, as between those two categories of occupiers, I mean, who would you imagine typically to have more visitors coming and going, for example? People staying short-term, probably tourists, or permanent occupiers?
It's permanent occupiers. I mean, short-term tourists will you assume are out all day visiting. It's permanent residents that will have more visitors, whether it's friends, whether it's delivery people, obviously in terms of food deliveries, Amazon, work people or whatever. But it's no, I think permanent residents will have significantly more delivery activity than transient tourists.
Yeah, I mean, in terms of comings and goings generally, then, what do you say about the suggestion that transient occupiers generate more comings and goings than permanent occupiers? Is that?
Well, I don't see that they do. I mean, they arrive, they go out visiting, sightseeing all day. They might come back in the evening and then go out again. But you wouldn't expect a tourist to London to spend all day, on site. Whereas, obviously, a permanent resident might, and they would certainly have more comings and goings associated with domestic living.
Thank you. And two final questions on this point. First of all, if the council's concern is with the occupiers at 4th floor level, I mean, what, if any, comment do you have when you're talking about noise and disturbance about the fact that the 4th floor is above rather than below the units that are the subject of the notices?
I mean, in my experience, when you tend to have noise amenity issues like this, it's actually the floor above that tends to generate the noise for the floor below, in terms of, noise on wooden floors or whatever. It doesn't tend to be, in my experience, the other way around so much.
Yeah. And in terms of comings and goings and noise and disturbance to the building generally, first of all, what's the relevance of the use at ground floor level to noise and disturbance generally in this building?
Well, the ground floor use is a drinking establishment, which is open late. I mean, it's open till 2 a.m. At the weekends. It is busy. I mean, I've most recently visited the site this week on Tuesday. That was about 10:10 in the evening, and the Hoxton Pony was busy. You know, there were several groups of people. There's tables outside. There were several groups of people sitting outside on the pavement. It was quite warm on Tuesday evening, and no, it was busy. It was noisy. There was music going. You know, it is a drinking establishment that's open late.
Thank you. I think the last amenity point I want to ask you about is that there was a letter sent in as part of the appeal process by an interested person in respect of rubbish refuse, wasn't there?
Yes, there was.
And then two questions, please, in relation to that point. The first is there any basis for suggesting that there would be more rubbish or refuse generated by short-term occupiers compared to permanent occupiers, in your view?
None at all. In fact, I would say there would be less. And
secondly, if the inspector did regard that as being an issue, to what extent do you say that can be satisfactorily addressed?
It can be satisfactorily addressed through an operational management plan, and indeed we have suggested one in evidence. So yes, that can be dealt with through an operational management plan, which can be attached through any condition.
Good. That's all I'm going to ask about amenity. I just want to ask you briefly, please, about two other policies in the development plan. You spoke earlier, didn't you? You made a reference to policies pulling in different directions. And I want to ask you about two policies. And again, can we pick up as our starting point the statement of common ground and have a look at section 7?
Sorry, 1 second. Section 7.
Yeah.
Yes, I have that.
And can you see under the heading, the London plan? Again, we saw it earlier. The council considers only H8 to be relevant. The appellant considers the following to be relevant. And you'll see the inclusion there of E10. Yes?
Yes.
So E10, a policy that the council don't accept as relevant. Can we have a look, please, at policy E10? Which in the London plan, if you're looking at the hard copy, is at page 273.
Yep.
Now, so far as this policy is concerned, it's the policy that is labelled visitor infrastructure.
Yep. Yes, I see that.
And at A, it talks, doesn't it, about London's visitor economy and associated employment should be strengthened, and references within the body of the paragraph to the visitor experience and so on.
Yes, I see that.
And then specifically at paragraph C of the policy, what does that tell us, please?
C says a sufficient supply and range of service accommodation should be maintained.
Thank you. And if you then have a look at F, we are within the CAS, aren't we? You've established that already.
Yes, that's correct.
And then it says strategically important serviced accommodation should be promoted in opportunity areas. So that is if we're in an opportunity area. And if we're in the CAS but not in an opportunity area, it refers to smaller scale provision in other parts of the CAS, except wholly residential streets or predominantly residential neighbourhoods. And just in case that just in case it was thought we weren't in an opportunity area. I mean, is this a wholly residential street or a predominantly residential neighbourhood?
Certainly not.
And if we go down, please, into the policy to paragraph H, that talks about accessibility and wheelchair accessibility.
Mhm.
And so far as each of the apartments, the subject of the notice, I mean, do they have wheelchair accessibility?
They do not, no.
And when the inspector's considering that in the round, when looking at this policy, what weight do you say the inspector should give to the fact that the use doesn't satisfy H of E10?
Very little. I mean, the lack of wheelchair disabled access is simply due to the nature of the building. It would equally apply to the requirement for accessible residential units.
Yeah. And looking at the policy overall, E10, does the policy E10 support or work against the use as service apartment at this building?
It actively supports it.
Yeah. And put that to one side. We're going to come back in a moment to the supporting text in the context of need, but can you then take up what may be the final development plan policy we'll look at, which is LP25. And for ease of reference, so we've got that in Mr. Sutton's proof of evidence. It's set out at paragraph 8.30 on page 29. Yeah.
Mm-hmm, yes.
And this is the visitor accommodation policy within the local plan. So we've got the London plan policy, which is E10, the local plan one, which is policy 25. Yeah.
Yes.
And it refers, doesn't it, to up-to-date assessments of demand. And in your proof, we'll come to it in the context of need. You set out the GLA economics assessment of demand. Is that the most up-to-date?
The GLA working part paper that I referred to in my proof and which sits behind the London plan policy E10 is the most up-to-date information.
Yeah. And what, if anything, is the relationship between that assessment and policy 25?
The need evidence in E10 supersedes the LP25. LP25 is based upon an earlier GLA working paper.
All right. And if we look, please, at the criteria in policy 25, and noting that the references to all of the criteria needing to be met, but just looking at those, please. So first of all, so far as little one,
I think we've lost the inspector. That's the grant.
Ah. I don't know when. Did you notice when?
Very, very shortly ago. I'm about to go back a question, and I think we're probably there. But let's wait for him, and he can tell you from his notes.
Thank you very much indeed.
I actually lost sight of him a few minutes ago, but I thought it was just me.
Okay, we'll just hold on, I think.
Hello, is everybody there?
So yes.
I'm terribly sorry. My network just failed, so there's nothing I can do about that. It's come back. Mr. Grant, I interrupted you. You were on paragraph F, and you were talking about opportunity zones and CAS.
Ah, okay. That was. I hadn't realised you'd gone that early, but we'll.
I tried to say, but it just
Yeah, not at all.
it just went.
So can we go back to policy E10, please, Mr. Sutton?
Yeah.
And we were looking at F and the references there to service accommodation within the CAS. You see that? Promoting strategically important service accommodation in opportunity areas.
Yes.
Outside of the opportunity areas, smaller scale provision, except wholly residential streets or predominantly residential neighbourhoods. You see that?
I see that, yes.
In case there's any issue as to whether or not the site is in an opportunity area, it is the area here, it is Curtain Road, a wholly residential street or in a predominantly residential neighbourhood?
Absolutely not, no.
Now, so far as G, I then took you to paragraph H of the policy, which is about wheelchair accessibility.
Yes.
And so on. And you indicated that none of the service departments that are the subject of the notices are able to meet H in terms of that level of accessibility. And the next question I asked you was the weight that you, in your view, the inspector should give to the fact that none of the apartments would satisfy H.
Yes, and I don't think you can attach any weight to it. The lack of disabled wheelchair accessibility is the nature of the building, and that equally applies were the site to be in residential use and the need for accessible residential units.
Mm. And when you look at policy E10 as a whole, what do you say about whether or not the user's service department in each notice is consistent or inconsistent with policy E10 overall?
It's wholly consistent.
And put it another way, is it supported or undermined by policy E10?
It's wholly supported by policy E10.
And then if you put that to one side, and I'm saying it for the second time, but we'll come back to some of the supporting text in a minute when we talk about need. But can we then look at the second policy that I wanted to take you to, which is policy 25 of the local policy. And we were looking in your proof on page 29, paragraph 8.30, where you set that out.
Yes.
And in terms of up-to-date assessments of demand and supply, what you're telling us before was that the up-to-date assessment is the GLA working paper that you set out the number of tables from it, didn't you, in your proof of evidence?
Yes, that's right. So the GLA working paper 88, which I refer to in my proof of evidence, is the most up-to-date assessment of need, and it is that working paper which underpins policy E10 of the London Plan, which obviously is a 2021 document. The need information which underpins Hackney policy LP25 is actually an earlier GLA working paper 58, which is actually from 2013. So the need assessment in the London Plan and the need assessment set out in my proof is more up to date than any need assessment which underpins policy LP25.
Yeah. Does that mean it's an updated version of the same paper, effectively?
Yes. Yeah.
And if we just have a look at the criteria then contained within policy 25, and noting that it refers to all of the criteria to be met, and going through them, I think, reasonably swiftly. First of all, not result in total supply of visitor accommodation significantly greater than the projected demand, or would that be the consequence?
No, it wouldn't.
Second, not lead to an overconcentration of similar uses in the locality. Would that be the consequence?
No, it would not.
Third, we'll have to come back to this, but not result in the loss of general purpose housing or opportunities to provide conventional C3, I think you've written C5 actually, or CS, C3 housing. Would that be the consequence?
No, it wouldn't.
Fourth, complementing the balance and mix of uses in the area, character and function of the area, and its compatibility with surrounding land uses. We've already dealt with that. Would that be a consequence?
It would do that, yes.
Sorry. Yeah. And five, not cause an unacceptable level of disturbance or loss of amenity to occupiers and surrounding premises. Again, we've dealt with that. Would it have that result?
It would not, no.
And finally, 6 and 7. At 6, make adequate provision for servicing and pickup and set down points for taxis and coaches. We'll just amplify that as well. But firstly, would it make adequate provision for servicing and pickup by taxis and coaches?
Yes, there are ample loading bays picking up points on Curtain Road, and there is Curtain Place immediately adjacent to the building as well.
Yeah, okay. And 7, include at least 10% wheelchair accessible bedrooms. You've already indicated that it doesn't do that, does it?
It cannot do that, no.
Now, so far as those criteria are concerned, they are expressed, aren't they, collectively? So all of the criteria need to be met, aren't they?
Yes.
And so on a strict interpretation of policy 25, by failing little 7 in respect of the wheelchair accessible bedrooms, does the use of service apartments meet policy 25 on a strict interpretation?
In a strict interpretation, no, but only on the basis that it fails criteria 7.
Yeah. And so when you look together, please, at the 2 local plan policies for visitor accommodation, 2 development plan policies for visitor accommodation, being E10 and LP25, when you look at those together, do they support or work against the use of service apartments here?
Support.
Good, thank you. Can we move then to, before we move to material considerations, can you see, please, in policy 25, little 3,
yes.
and the reference to opportunities to provide C3 housing?
Yes.
Yep. And then can you take up, please, the statement of common ground?
Yep. Yes, I have that.
And can you turn, please, to the penultimate page and the central section of the page under the heading of principal issues between the parties?
Yes, I have that.
And do you see the first of the first in the list, whether the development results in a loss of housing? Yeah.
Yep.
And then in brackets, for the purposes of the statement of common ground, the council wish to add to this or the opportunity to provide housing, although in the appellant's view, this has never been part of the council's case.
Correct.
See that?
Yeah.
And so far as that is concerned, let's assume, please, that the reference to opportunity for housing is rooted in policy 25, little 3. Yeah?
Yes.
First of all, was there any reference in the delegated report or in the notices to a loss of opportunity in respect of C3 conventional housing?
Sorry, loss of C3 housing. Yes, there was.
No.
Sorry.
Loss of opportunity.
Opportunities. No, there wasn't a loss of opportunities. No.
And can we have a look, please, at the first of all the delegated report, which is in your appendices at Appendix 7.
Yes.
You see there 6.12.
Yep. Yes, I see that.
The unauthorised development involves the loss of 24 residential units, which is unacceptable in principle. Is there anything in the report, either in that paragraph or anywhere else, about the loss of opportunity for housing?
No, there isn't.
No. And if you have a look, please, in the report at section 4.
Yes.
And you'll see there a list of policies, and you'll see a reference to policy DM27.
Yep.
Now, is policy DM27 the predecessor of policy 25?
It is, yes.
Hotel policy, it's described as. And at that time, did DM27 say anything about a loss of opportunity for housing?
No, it didn't contain that.
No. And then if we have a look, please, at the council's proof of evidence.
Yes.
And this was only obviously 28 days ago, wasn't it? Can we turn, please, to paragraph 7.32?
Yes.
And do you see 5 lines from the bottom of 7.32, a reference to the loss of 24 residential units?
Top of page 11, yes, I do.
And then over the page, paragraph 7.34, in respect of LP 25. Yeah?
Yes, I see that.
Penultimate line, do you see there the loss of 24 residential units is contrary to this policy?
Yep.
And it says, as criteria C3, 5, 6, and 7 are not met. You see that?
Yes, I see that.
And a little Roman numeral 3 is the limb that we were looking at a moment ago, isn't it? Which talks about loss of housing or the opportunity for C3 conventional housing. Yes?
Yes.
And what did the officer in his proof give as the reason for the conflict with little 3 of C?
It's simply the loss of the 24 residential units.
Yeah. And then look in the, there's then some number duplication of the paragraphs. But if you look 2 paragraphs below, 7.35.
Yes.
3 lines up from the bottom, do you see again a reference to the loss of 24 residential units?
Yes, I do.
And then in the next paragraph, which is again numbered 7.35, but can you turn to the final sentence of that?
Yes, I see.
Does that again refer to the loss of 24 residential units?
It does, yes.
And is there anywhere that you found anywhere in the council's evidence which indicates reliance on the loss of opportunity for C3 conventional housing?
No, not at all.
And just taking that point and looking at it, what do you say about whether it's appropriate, whether or not it's appropriate for the inspector to approach these appeals as if this was one notice covering the building rather than 24 individual notices, each covering an apartment? What do you say about that?
That would be manifestly wrong. There are 24 separate notices that have to be considered individually and independently.
Yeah. And in respect of each notice, what do you say about the opportunity for C3 conventional housing in respect of each of those apartments?
Well, I mean, the key phrase there is conventional C3 housing. Conventional C3 housing is subject to national space standards. All of the 24 apartments fall below that. So it must follow that there are no opportunities for conventional C3 housing in any of the 24 apartments.
Yeah. Good. We were going on to material considerations, and firstly, please, the NPPF, we can deal with this one very briefly for these purposes. You don't need to turn up the NPPF actually, but we can have a look first of all at the Statement of Common Ground. Again, section 7, that's the policy section.
Yes.
The council consider only section 5 of the framework to be relevant. That's about housing, isn't it? Supply of
It
housing.
is, yes, yeah.
The appellant considers the following to be relevant. Now, I'm not going to go through all of those with you, but section 8, you refer to paragraphs 81, 82 and 83, don't you?
I do.
And did the council agree or disagree that those are relevant to the inspector's determination under ground A?
They disagree.
And then can we have a look, please, because you deal with those in your proof of evidence. And you set them out at page 26.
Yes.
And let's just look in particular here at 8.11 and 8.13 in your proof. 8.11 deals with paragraph 81. Policies and decisions should help create the conditions in which businesses can invest, expand and adapt.
Yes.
Significant weight should be placed on the need to support economic growth and productivity, taking into account both local business needs and where there are opportunities for development. The approach taken should allow each area to build on its strengths, etc. You see that?
I see that.
Now, so far as that policy is concerned, relating to business and the economy, does that policy support or undermine the development in each case here?
It supports the case for serviced accommodation.
Yeah, and have a look at 8.13 that refers to paragraph 83.
Yep.
Paragraph 83 talks about decisions should recognise and address specific locational requirements of different sectors. What do you say about the locational requirements for the visitor accommodation sector?
It needs to be, it certainly needs to be located centrally within the central activity zone and also in close proximity to a major transport node. And obviously the appeal site here is in close proximity to both Liverpool Street and Old Street.
And so far as section 8 is concerned of the, or chapter 8 of the framework, building a strong competitive economy, what weight do you say that the inspector should give that in the overall balance?
Significant weight. It's national planning guidance.
Yeah. Second material consideration I want to ask you about, please, is need. And if we have a look, please, in your proof of evidence, starting on page 8.47, your need section begins there. I'm not going to take you through the whole thing, but I'm going to ask you to keep your proof open and pick up again policy E10 in the London plan.
Yes, I have that.
And can you have a look, please, at the supporting text to the London plan at 6.10.2?
Yes.
And do you see there text relating to meeting the accommodation demands of tourists? And then it's estimated London will need to build an additional 58,000 bedrooms of serviced accommodation by 2041.
Yeah.
And if you turn over the page, please, page 275.
Yes.
Can you see there footnote 125?
Yeah.
Footnote 125 arises out of the paragraph of the text we were just looking at. And does the footnote relate that need to the working paper of working paper 88, GLA Economics?
Yes.
And then you include, don't you, the tables from that paper within your proof of evidence.
Yes.
And can we just start, please, and have a quick look at table 4, which is on page 38.
Yes.
And that deals, doesn't it, with serviced accommodation by borough as of December 2015.
Yes.
And it lists all of the boroughs, doesn't it?
It does.
And it identifies Hackney as the as having the 17th greatest supply of serviced accommodation rooms in London out of the boroughs. Yeah.
Yeah. 1.3%.
1.3%. And then if we have a look, please, at table 14, which is on page 40 of your proof of evidence.
Yes.
So table 14, and this is the projected demand for serviced accommodation rooms in London to 2041 by borough.
Yes.
And the first column is the total change in net room demand. And if you go to the very bottom of that column, you can see the total aggregated to 58,140.
Yes.
Presumably that corresponds to the 58,000, doesn't it, in the London plan that we were just looking at. And having been 17th in 2015, in terms of the projected demand, where is Hackney in the list now?
It's gone up to 6.
And having had a share in London of 1.3% in 2015, by reference to the demand projections, what is the Hackney's share projected to be for 2041?
It's now gone up to 5.9%.
Yeah. And in terms of rooms, if we look at just gross numbers, so the third column, do we see there 4,490 rooms by 2041?
Yes.
Up from 1929, the figure in 2015 that we just saw in table 4.
Yes.
Yeah. And aside from the position in Hackney specifically, I mean, as with housing need, is the correct approach, in your view, to look at the borough on its own or to look at it on a London-wide basis?
But both really, but London-wide is equally applicable.
Yeah. And just wrapping up this point, please, what do you say about the need for serviced accommodation in Hackney and in London, and the weight that the inspector should give that?
There is significant need for additional serviced accommodation based on the projected growth. So that is something the inspector should give significant weight to. And I think possibly since that was published, the building back better post COVID, it becomes even more important. So it's a significant material consideration for which significant weight should be given to.
Yeah. Third material consideration, please, is the suitability of the area for visitor accommodation. You discussed that in your proof and already quite extensively in your oral evidence. But so far as the suitability of the area for visitor accommodation, what weight do you say the inspector should give that in the planning balance?
Again, significant weight. The proposed, the serviced accommodation use is wholly suitable for the appeal sites.
Thank you. And then the fourth of our 5 material considerations, the quality of the visitor accommodation provided by each of the serviced apartments. Now, you've identified that there's no wheelchair accessibility, but what do you say overall in respect of each apartment as to its quality as a serviced apartment?
Overall, they're very good. They have the finish is very good. The quality of the accommodation, quality of the products within the units is good. The quality as serviced accommodation is very good.
What about the quality of the services provided?
It's good. As I say, there is maintenance, it's cleaning, laundry. So the services provided, Wi-Fi is all quality, good quality as well.
And the quality of the interiors that are provided?
Good quality. It's nice finishes. There are nice products there in terms of the TV, beds. It's good. It is nice accommodation. It is good quality accommodation. Absolutely.
Thank you. And then the last, please, of the 5 material considerations, the fallback position or baseline position. If, first of all, if the inspector is satisfied that the lawful use remains hostile use, in respect of each apartment, is there any material harm, planning harm, in the use as a serviced apartment rather than a hostile use?
No.
Second, if the inspector concluded that the lawful use was the residential C3 use in respect of each apartment, yeah.
Mm-hmm.
What do you say? And we'll break it down in a second. But what do you say about the quality of the living conditions that would be provided by each of those apartments if they reverted to that use?
It would be poor quality.
And can you just take up the possibly for the last time the council's proof? And if you go to paragraph 7.49,
yes,
it says there, the cessation of the use as a serviced apartment in compliance with the notice does not preclude the appellant from using each unit as their lawful use, and therefore continuing to benefit from the property economically. Do you see that?
Mm-hmm, I see that.
So if that is was the upshot, and the appellant used each unit as a C3 residential use, so far as space standards are concerned, can you pick up the statements of common ground?
Yes.
And can you whiz forward, please, to paragraph 10?
Mm-hmm, yes.
And you'll see there a table which is agreed, doesn't it, which sets out the floor space of each unit.
Yes.
I think the largest one we can see is the numbers 7, 14 and 21, which are 20.4 square meters. Even taking the largest of those units, how significant is the shortfall against the relevant space standard? And what is that standard?
That shortfall is massive. So the absolutely smallest unit that you can have for a studio or 1 bedroom is 37 square meters with a shower. It's 39 with a bath. So the largest unit here is only marginally over 50% of that figure. So it's well below.
And I mean, there are a dozen in this list which are below 14.5 square meters. I mean, what do you say about those when you compare to the standards?
I mean, they're well below less than half the required size.
And are those standards expressed as minima or maxima or a target? How are they expressed?
They are minimum sizes.
Yeah. And so far as the other living conditions, what is provided in terms of private external amenity space?
Nothing.
What about communal external amenity space?
Nothing.
What about aspect?
All of the units are single aspect.
Yeah. Were you to be approached by a client wanting to apply for planning permission for a C3 residential unit that measured somewhere between 13.5 and 20.5 square meters with no external amenity space, private or communal, what prospect would you advise that client that they had of success?
Zero prospect.
What do you say about a local authority here promoting effectively the contribution to London's housing stock of flats with these living conditions?
I really don't understand it. The units do not meet the required standards. That is unequivocally the case. So I do not understand why the council is promoting it. If I was to submit this scheme for a pre-application to Hackney, I have no doubt whatsoever it would receive a fairly swift response in terms of its unacceptability, and that's before we even touch on issues of housing mix and other matters.
And you spoke about your view that the serviced accommodation is of a good standard. I mean, if the inspector were to conclude that he's effectively faced with a choice here between substandard C3 flats or good standard serviced accommodation, where do you say the balance should lie?
And good quality serviced accommodation, which is supported by planning policy, the weight squarely falls on serviced accommodation as being the most appropriate use. Yeah.
Lastly, on ground A, if the inspector were to conclude that there was conflict with the development plan overall, how do you say that conflict would weigh against the material considerations if he accepted all of the council's arguments in terms of conflict with the development plan?
I think on balance, the relevant material considerations are in favour of a grant of planning permission in that respect.
Thank you. And lastly, and very briefly, on ground G, I think just 3 quick points on ground G. First of all, you identify in your proof of evidence bookings, particularly for next summer, as being a reason to justify the extending the compliance period. And the council made the point, well, that's just a private economic benefit for the owners. I mean, do you agree that that's just a private economic benefit, or is the benefit wider than that?
No, not at all. I mean, there is an economic benefit to Hackney, to Shoreditch, to the local area from the tourism economy and from visitors to the site. And that's the whole basis within the London plan in terms of promotion of tourism. It's the economic spin-off benefits that flow from that. So it's not simply a private economic benefit. That's
thank you. And lastly, thank you. And lastly, in your proof under ground G, you referred to the potential to submit further applications, and a longer period would allow that. I mean, by way of an update. Now, so far as you understand it, and on the basis of the way in which the case is developed in terms of fallback positions and so on, I mean, as you understand it, how likely is it that fresh planning applications would be submitted in the event of these appeals failing?
Not the case.
No. Good. So those are all of my questions. Thank you very much indeed.
Thank you very much, and I'm sorry about the interruption.
No, not at all.
Then, Mr. Streeton, it's cross-examination, but obviously it's time for lunch. So, could you arrange in lunch hour for your appendices to be sent through to me, please?
Yes, absolutely. I'm sorry they haven't found their way to you. I know they were sent, but they've got lost in the queue.
Oh, okay. If they've been sent, they will get through. It's just it gets a bit of a turnaround in pins. So, thank you for that. Then, can we, if I say meet back at 2 o'clock, would that be too soon?
No, so I think that's acceptable from our end.
Okay, then the inquiry is adjourned, and we will resume at 2 o'clock. Thank you all very much. Thank you.
Good afternoon, Mr. Sutton. Can you hear me clearly?
Yes, Mr. Streeton, I can. Thank you.
Grateful. Now, you don't challenge, do you, that the current use of the 24 units enforced against are as separate 24 service apartments? That's your proof of evidence 5.3. Is that right?
That's correct. Yes, there's no dispute with that.
And you don't dispute that at present each is a separate planning unit?
No, we don't.
But these appeals have been conjoined, haven't they?
They have, yes.
And you'd agree that the appeals are interrelated?
Only in so much as they deal with the same issues.
Well, not only that, because they also deal with the same building, don't they?
Yes, it's the same building.
And you'd agree that it's appropriate to consider the issues arising together and as a whole?
Well, the issues are interrelated in that the issues apply equally to each individual unit. Yes, I agree with that.
You also agree, don't you, that in an enforcement appeal, the burden of proof is on the appellant to demonstrate his grounds are made out, with the standard of proof being the balance of probabilities?
I agree with the balance of probability, but I think with an enforcement appeal, if the appellant says that that is its position, then obviously it is that the council needs to justify its position in terms of the basis for issuing the enforcement action.
Well, no. If you just look at the planning encyclopedia, and I think this was sent through yesterday, P174 spot 1.2, when you've got that.
Sorry, bear with me. This was the bundle of stuff that was sent through last night.
Yes.
Sorry, say that again.
Within that, it's the commentary on section 174, and it's P174.1 and it's sub-point 2.
I don't think that was one of the documents sent through, actually.
I think it was, but
We've got one. It was the sections relating to 191,
Yes,
176, 171, and 177.
I sent through 4 documents from the encyclopedia. 8 documents in total, 4 cases, 4 sections. The first of those was section 174.
No, it wasn't. It was 171, 176, 177, and 191.
That's what I have.
That's what I have as well, I'm afraid.
Right. Well, just so that I understand, is it then your case that the burden of proof is not on the appellant to demonstrate on the balance of probabilities that its grounds are made out?
This is an enforcement inquiry, not a certificate of investigation to a certificate of lawfulness. The appellant's position is very clear on the lawful use. It is, to quote a phrase earlier, it's unambiguous. Our position is the lawful use of this, of all of the appeal sites, is hostile use.
I'll come to that. But just as a broad statement of principle, are you accepting or not accepting that the burden of proof is on your client to demonstrate that each of the grounds is made out?
In terms of the burden of proof, I'm comfortable that we have demonstrated, and it is our position that it's a hostile use.
I'm going to interrupt there. But it's clear the burden of proof is on the appellant to make out their case in enforcement cases. I don't think you need to argue that unless you.
Take the point, sir.
Good. If we then turn to the question of what the lawful use is, and first the facts. Now, your client acquired the appeal site in August 2011. That's your proof of evidence 3.14.
Yes.
And so on that basis, it's owned the appeal site now for in excess of 10 years. Is that right?
Yes.
Now, your case, as I understand it, is that its lawful uses as a hostel in accordance with Appendix 8, the Planning Commission granted in 1994. Is that right?
Correct.
And the first time you raised that argument was in your proof of evidence. Is that right?
I would need to just double check, but I'm happy to take your happy for that to be confirmed.
I don't think it hugely matters because
Yeah, no, I'm not disputing you, Mr. Stritton.
Now, if we then turn to that permission, it's granted subject to a number of conditions, isn't it?
It is, yes.
And conditions 2, 3, 4, and 5, or 2, 3, and 4 are what might be called pre-commencement conditions, and 5 is a preoccupation condition.
Yes, I agree.
And they require discharge of various matters before the planning permission can be implemented, including the submission of plans, details of samples, and so forth.
Yes, that appears to be the case. Yeah.
Now, there has been no discharge of any of those conditions, has there?
I'm not aware. Yes or no.
Well, put it this way: there is no evidence that any of those conditions were ever discharged.
No, not within my evidence. No.
No. And the only plan that was available on the council's planning file that we've submitted, you said in your chief.
Can we just hold on a second? Mr. Grant has got a question. I think I know what it will be.
So yes, these questions seem to be parasitic on what the council is saying is in the planning file that we've not seen, other than the drawings that were sent through to us. Of course, this is a file from 1994, which was 17 years before the appellant company acquired the property. And it sounds as if, unless I've misunderstood it, it sounds as if there are questions being put based on what may or may not be in a planning file that hasn't been disclosed to us.
I find it astonishing, actually, Mr. Streeton, that this line of inquiry is just going on because the appellants have no prior knowledge of this to have either looked it up or asked their clients whether the conditions were discharged or not, or whether there's any problem. You're putting very new evidence. I mean, it is a surprise attack, really. I'm absolutely astonished that you've done that.
So it's with respect, it's not a surprise attack because the burden is on the appellant, and the appellant only in its proof of evidence raised reliance on this planning permission. I am then entitled to ask if he has proved that this planning permission was implemented.
Well, the planning permission is there, and the building's being used, and the appellants have assumed that is the case, obviously. And if you had any doubt when the proof came out, if that's the first time it came out, surely that's the time that you put it back to them. If you're right, it's fundamental to this inquiry, and the appellants don't want to carry on, then it could have ceased the inquiry if that were the case. You know, it's just really unacceptable to be bringing this line of inquiry up at such a late stage without informing the client, with the appellants.
So, in my submission, it's not a new line of inquiry. The council's position has always been that the previous use was residential. The appellant then relied upon this consent. There's nothing to suggest it was implemented. The council has gone away to get the planning file, which...
It's never been the council's case that it wasn't implemented or it wasn't a valid permission. That has never been put forward. I understand your case was it's residential, and I'm happy with that. That's your case. But not that this permission has never been brought into doubt until this moment.
So the existence of the permission is not in doubt, but its implementation is. And if the appellant wishes to...
But that's my point, that no one knows that its imposition was in doubt until you've just raised it. That's the point I'm trying to make, that we could have all have had this in our notes and thought about it, but it's the first time that anyone's had any knowledge of that.
Well, I mean, as I said, I only got the planning file this morning. And
don't get me wrong, Mr. Street, and I'm not getting at you because of this. It's the council's case that I'm attacking, so don't take it personally by any means. But the point is that Mr. Grant, I mean, this is obviously a completely new line of evidence coming to you. Are you going to need time to fact it away, or whatever you need to do to consider it?
So I'm just not in a position to deal with it. We don't know what's in the file. I've not been able to take any instructions about it. Mr. Sutton hasn't been able to prepare to deal with it. And can I just add this, that in respect of the suggestion, if this is the suggestion that's being made, that the council only in their proof of evidence, which in any event was 4 weeks ago, only in their proof of evidence raised reliance on the 1994 consent. That's nonsense, because the council's statement of the appellant's statement of case referred to the fact that the appellant took the view that the lawful use remained hostile, and there's then in Appendix 6 the whole sequence of correspondence that you will have seen, in which the appellant makes perfectly clear their reliance on a 1994 hostile consent. So to suggest that this has come as something new, albeit 4 weeks ago, is not correct. And I feared this, I'm afraid, when I heard reference to the file this morning.
Yes.
That we had, a part of it disclosed to us this morning. And I had imagined and hoped that if part of it was being disclosed, we wouldn't find ourselves in a position where references were made to other parts of the file without actually telling us that it was going to be referred to or allowing us to see it.
Well, I'm not quite sure what to do, Mr. Dean. Do you want to comment?
Well, so my submission is that the statement of case did not rely on the 1994 commission. That was a point brought through essentially in the proof of evidence. As I say, if Mr. Sutton's case is that he relies on the 1994 commission, then he needs to make that good on the balance of probabilities. Now, so I do say that this is a case where initially the appellant put its case on ground D. It said it was going to explain how the property was used throughout the 10-year period. In its proof of evidence, it didn't do that, and it seems very clear from the evidence that came through in chief that there are a series of documents or pieces of information not provided by the appellant, which deal with how the site has been used. It's been in single ownership since 2011, and there's been nothing of that. There are contradictory statements in the evidence, which I'll come to look at, and essentially it seems to me that what's happening here is the appellant is seeking to sit on its hands. It's the person that holds all the information, and to leave it to the council to make a positive case in circumstances where the burden should be on the appellant.
Well, that may be the case, that you've got to show your case as well as theirs. But what I'm concerned about is this: the planning permission. I mean, do you not accept that the then person who got the permission then purported to implement it, even if he didn't comply with the conditions?
No, there's no evidence that happened.
Well, there's the layout of the building and everything. That's all.
The layout doesn't record. Firstly, there was no approved layout, so they're pre-commencement conditions, and secondly, the layout doesn't accord with the layout in the plans that were submitted indicatively.
Well, we can talk about that, whether layouts can change, building can change. But why didn't the council then take action against breach of condition?
So it wouldn't have been.
Isn't that what you should have done if you thought the conditions had been breached and the planning permission had been implemented without being properly implemented?
Well, so there's no evidence of the hostile use taking place. There's evidence of a residential use taking place, and it's a question for the council whether or not it enforced against that residential use. It's a question solely within their jurisdiction of expediency.
Well, I find it difficult. But Mr. Grant, tell me what you would like me to.
Yeah. Can I just thank you. So just to put this into its proper context, first of all, it has been absolutely clear, going back to the statement of case and then to correspondence back in the early part of this year, that the appellant's case is that the lawful use is a hostile use. That can only arise from the 1994 consent. That was clear in correspondence from something like eight months ago. So that's the first thing. Secondly, the learned friend talks about the appellant sitting on information, but he's seeking to cross-examine about information that preceded the appellant's acquisition of the site by 17 years. Third, even if the council were given the benefit of the doubt and the first thing they knew about this was 4 weeks ago, the first time it's been raised by them as a as a contentious matter in terms of implementation was this morning. Fourth, if it's not bad enough that it's never been raised before, the last 2 days have been spent with a draft statement of common ground going backwards and forwards between the parties, which has included identifying a whole raft of issues arising between the parties. Nowhere within that statement of common ground has there been any suggestion or attempt to suggest by the council that implementation of the 1994 consent was in issue. And fifth, and just to put this in the wider context, sir, of this as part of what is now clearly a pattern is that within the last 48 hours, we have had first the council seeking to introduce as an issue between the parties a reliance on opportunity for housing, which was never previously part of their case. We have had second, at 8 o'clock the night before the inquiry was due to start, a whole series of about half a lever arch file worth of documents sent through to the appellant team that the council wished to rely on. Third, we had this morning, at the start of the inquiry, the council seeking to rely on planning drawings, which had never been put in before. And we now, fourth, halfway through the first afternoon of the inquiry, have not only the council raising an issue as to implementation which hadn't previously been raised in spite of countless opportunities to do so, but the learned friend seeking to put to the witness what may or may not be in the file that has never been disclosed to the appellant. So you, of course, have a discretion as to how the inquiry should be run, and a discretion as to whether or not to allow the council to reinvent their case. Now, certainly for the second part of it that's been reinvented at the last minute, and whether or not to allow the council to rely on documents that not only haven't been put in, but that we haven't seen. And in my submission, the appropriate course is to say to the council that it is not right, bearing in mind all of the procedures that are there, to develop their case, what appears to be, frankly, on the hoof. And secondly, to rely on documents that not only aren't in, but that we haven't seen.
But, well, Ms. Street, I agree with that. That I think if you're going to rely on this line of approach to your case, then the documents that you're relying on really need to be seen, and because no one knows whether that it is correct or not, and whether the conditions were discharged or not discharged. And I think if you're going to rely on this, I'm going to ask for that evidence to be submitted, and so that Mr. Grant can consider it.
So I say two things, the first thing is that I obviously don't object to the appellant being permitted to inspect the planning file. I do say that the planning file is a matter of public record. The burden is on the appellant, and if it was intending to rely on this permission, it was incumbent upon the appellant to inspect the planning file to present its case. It's not the council's fault that it's relying on the absence of evidence, which is what it's doing. The second thing is, Mr. Grant said, well, it must have been the 94 permission that was relied on for hostile use. So that's not right. The appellant had previously indicated that it was going to run a Grand D, and so it was understood that what was going to be said is the use has not changed over a period of 10 years. That's no longer the case put, so it's not said that it was a hostile for a 10-year period. And so the 94 permission becomes of significant importance as a result of that. And it's because of that that the council's case has to deal with the 94 permission.
The council, I don't object to you dealing with the 94 permission. I think that is perfectly proper, and you should do that. But you should do it in the correct procedure and let everybody know what your case is about the 94 permission. As it stands, if I was reading the council's statement of case, I, like Mr. Grant, would read it that and reading those reports that the previous lawful use was C1. And I would read it that came from that 94 permission. I wouldn't be on warning to go and inspect it. If your case is this, and I don't say you can't make that case, but you've got to let the other side know so they can go and inspect the file. They know they've got to inspect the file. At the moment, they had no real. To me, no, I wouldn't have done it if I'd been in their position. I did not know this was an issue, and if I'm surprised, they're surprised.
So I hear what you say, but I think it is important to distinguish between the proofs of evidence and the statements of case, because the appellant's case changes between its statement of case and its proof of evidence. The council's case meets the appellant's statement of case, and it's because of the change in the proof that the council's case has changed inherently after it wrote its proof.
But there's been plenty of time for this to have been put to since the 4 weeks. For this to have been put, it could even have a phone call. Look, we don't think that planning permission has been implemented. Then it could have been. Everyone would have been known. But as I say, if you want to pursue that line of inquiry, I'm tempted to adjourn the inquiry so that the evidence is presented to the appellant so they can have a look at it.
Yes, so I'll take instructions, but I'm fairly confident that will be the council's desired approach.
All right. I'll come back to you in a moment, Mr. Grant. I'm flabbergasted, really. Anyway, Mr. Grant, do you want to say something?
I was just going to add one point, which is that the 2013 reports, which are in evidence, plainly acknowledge the council saying the last known lawful use was as hostile use.
I understand that. Yes.
And now the learned friend is suggesting that we should have not accepted that at face value, but decided nonetheless to go off and inspect to see whether that's right or not. I mean, it's a nonsense.
Your case is very weak on this, I have to say, Mr. Stratton. I find it astonishing that you're going to pursue it. It's, all the evidence doesn't point your way, I'm afraid.
Well, sir, I mean, I've heard what you say, but unless there are plans showing discharge of those consents, I don't see how it can possibly be said that permission was implemented. So I will take instructions on what the council wishes to do, but I hear what you say, so that you think the case is weak. I beg to differ.
Well, condition precedent, as you well know, I'm sure, is a very complicated area of planning law, and whether something becomes a condition precedent or not is something that really, well, I know I've dealt with it at length in many inquiries. And whilst a condition may say you've got to get prior commencement, it doesn't necessarily mean it's a condition precedent. So although you might on the face of it be able to say, yes, it was prior commencement, but if it didn't go to the heart of the decision, that wouldn't necessarily prevent the condition for the permission from being presented. I mean, we could get into a whole really difficult area of this case following this line, to follow that.
Well, I of course understand the importance of conditions going to the heart of the permission, but in my submission, where you have the conditions you do here, 2 to 4, it's quite clear that they do go to the heart of the permission, and I'm happy to make submissions on that as a matter of law.
Well, that's fine. Then come back again, Mr. Grant. What I'm tempted to do is just adjourn this inquiry, get the evidence submitted, and let. And we'll probably have to have new proofs of evidence because it's a whole new case. You must be aware of the cost of regime as well, Mr. Stratton.
That's why I need to take instructions, sir.
Yeah, okay. If you want to present, to me, it's new evidence. I would say that, and unless you can convince me otherwise, it's come as a surprise to me, and that means it's new evidence. So, and I will be treating it in that way, that you presented new evidence and a new case, and of course the inquiry to be adjourned.
I've heard what you say, sir, and I need to take instructions.
Yes. Well, what I'm going to do is adjourn the inquiry for half an hour, and then I'll come back and so hopefully you've had instructions. So it's 14:27. We'll resume the inquiry at 1500 hours. Okay, the inquiry is adjourned.
at the time when they went on, it was a residential use. They say the last known lawful use of 1 to 4 was as a hostel.
Yes.
But that may or may not have been right. But we certainly say it's not established that it was right.
Right. And that's your evidence, of course. But Mr. Grant, what do you want to do? I'm minded to adjourn the inquiry to get that. The difficulty I'm in is that what the council say to me is quite right, that whether that has a permission or not is a valid part of this appeal, and it's something that has to be looked at. And it's a key part of the evidence, really, that whether it has a permission or not. So I can't say, if I'm writing my decision, I can't say I agree with the council that it wasn't implemented. And I can't say I agree with the appellant it was implemented without having properly looked at the matter. So I'm sort of cleft stick really as to which approach. So in that case, I've got to get the extra evidence in to be able to make a decision. And if the council are going to pursue it, that it doesn't have that planning permission, which, as I say, is a key part of your case, then I think I've got to adjourn for some time to allow you to look at that. And Mr. Streeton, it may, I'm not saying it will, but it may be that it will cover not just looking at the planning file to see what happened, but looking at whether the conditions are condition precedents that actually stop the thing. Because my understanding, I'm not going to say I know this is correct, but my understanding is that after that permission, the building was changed to the hostel use. That's the way I'm reading it at the moment. It may not be quite as it was permitted, but one judge has said that when you're looking to see whether a permission was implemented, you don't just look at the things which aren't the same as a permission. You have to look at all the things which are the same as a permission as well. So it's not just simply a matter of saying the land's slightly different. You've got to make a judgment as to the whole permission.
I fully understand that. That's the commercial land decision that you're referring to, sir.
Yeah.
I fully understand the legal position. That's one of the reasons why I said that amended statements of case need to go, because I was mindful that you had said terms on whether it goes to the heart of the permission.
Yes.
I think all of this is potentially something which is best explored through the mechanism which I suggest, which is amended statement of case from us, amended statement of case from the appellant, proofs if necessary, and then return to the inquiry.
I understand, but I'm trying to set out to you both the issues are not, they're wider than the just looking at the thing and seeing whether they were done. I mean, the records are all on the paper file, are they? I mean, there's no computer records or anything like that. I don't know how your records just go to the paper file.
Yes, sir. And at least part of the explanation for the time taken was to find the paper file during the coronavirus crisis, as I understand, to isolate it, because it's not allowed to be touched by anyone having been retrieved by the first person, so on and so forth. Not that matters now. But it is a paper file only.
All right.
It's a physical file.
Well, I'm going to adjourn the inquiry. What I need to do then is find out when we can reconvene, because I really have to try and make a date for when it's ready. So I think what I'd better do is go and see when I'm available, and then come back to you, and perhaps you could have a look at when you're available, and we'll see if those availability dates meet. Can I just have a quick look at my computer? Just a second. At the moment, I've got some availability I could make available the 25th of October to the 29th of October.
So I have a 3-day trial in the High Court, 26, 27, 28.
Right. I could possibly do between the 18th of October and the 22nd of October.
I can do the 18th and 19th.
That would be all right for you. I'm just wondering whether that's going to give us enough time to do all this.
So just on the timing for the various stages that my learned friend has proposed, I won't comment at the moment on the substantive position he's taking, but just on the timing, I just wonder whether, rather than having a two-stage process of statements of case and proofs, it may be that we can actually deal with it in one stage for amended proofs. But what seems to me to be important if we do that is two things. First, that rather than having a mutual exchange date, that in the unusual circumstances we're in, that there's a break between the exchange by the service by the council and the response by the appellant, because we won't obviously have seen the material or the way in which the point is being put. But secondly, that if there is to be amended statements of case or proof, that we would be looking, sir, for you to direct the parties, if you're willing to do so, that the only issue to which the new documents can go is this issue of the 1994 consent and implementation. Because what I am worried about, frankly, is that I've got no faith in terms of the way things have been going as to whether or not we're going to receive otherwise statements of case and proof that open up a whole series of other issues. So we would invite you to make that direction if you are going to go down this route.
Well, if I go down that route, I won't ask for new proofs. I'll just ask for an addendum to the proofs to cover the particular issue and not the other issue. So it will be on this specific issue rather than that. So we obviously don't want to open up the whole situation.
Yeah. So the other, just one other procedural point I might make is that what we can perhaps deal with this again once we find a date. But what may be the most sensible way of dealing with things when we reconvene is to begin by reopening the re-examination of Mr. Sutton to pick up on the addendums.
I didn't quite understand that. Can you explain? Sorry.
Yeah. So far as this new point, of course, you haven't had evidence of that orally from Mr. Sutton.
Oh, I see.
Where we are, he's already started his cross-examination.
No, that's fine. No, you can re-examine the witness on that new matter. Definitely, yes. No, that's fine. Yeah.
So we would reopen evidence in chief to deal with that matter.
Yes.
What I'd be asking.
Yeah, absolutely. And that of course, that would be totally up there if I didn't allow you to do that.
Thank you very much.
Okay.
So, raise one other point at this stage, which was in Mr. Sutton's chief, and over lunch I went back and listened to the YouTube of his evidence in chief again. He referred to a significant explanation, we say, of what happened when the premises were purchased, how they were used in terms of tenancies then, and then a change in 2016 to 2017. I at the time intervened and asked what the documents were, and you said I could ask more questions about that. I would ask that, I do intend to ask questions about that because it's not been foreshadowed anyway. And if there are any documents relevant to any of that in the appellant's possession, Mr. Sutton requests them, and they also be provided with the proof so that we have all of the documents we need when we come to deal with it in cross-examination.
All right. Well, I'm happy for you to submit any documents relating to the use, if you have any that you want to submit, and then this would be the time to do that.
So yes, I mean the if I may say so, the way you've put it is the correct way of putting it, not the way my learned friend put it, which is to say that if it's the intention of the appellant to put in any documents to that point, we'll make sure that we do so as part of this process. But of course, what we're not going to agree to is effectively to be required by my learned friend to produce documents.
You know, it's up to you to present your own case.
Yes,
that's well known. That's fine. I'm still looking for dates. The other date I think might be actually more appropriate. Early November is difficult for me, but I could probably fit something in between the 22nd and 26th of November, and I think that might allow the exchange to occur more readily.
Just one second, so while I check my calendar. I'm afraid I am in the High Court from the 23rd, 24th, 25th, and 26th.
Right, that's no good.
so I can say that thereafter I'm not available because I've got a 2-week inquiry starting on the 30th, and then I'm away from the 13th. So if we can try and find some dates in October or November, if we can, even if that means squeezing the timetable a little bit to achieve that may be better.
November's a little bit tricky for me. What dates have you got in October then? I could possibly do the Monday or Tuesday, the 8th and 9th of November.
I can do the 18th or 19th. I can't do the week after, the week of the 25th.
I'm sorry, the 8th or the 9th?
8th or 9th.
I can do I can do both actually because that inquiry's gone. So yes, I can do the 8th and 9th.
October or November?
November.
It's November.
I'm afraid I'm in an inquiry in Northampton that week.
Right.
The week after I can, but that sounds like that may not be convenient for you.
It's my son's wedding and in France. I don't think I can put the inquiry off for that, put his wedding off for that.
I wonder whether we try to find 2 separate days, even if there's a break between the 2 days. Because it sounds like we may have between us the odd Monday or the odd Friday, for example. The difficulty is getting 2 consecutive days.
Could we do Friday the 29th and Monday the 1st of November?
Of November?
I can't.
No.
I wonder whether the end of that week of the 1st of November or the week of the 15th, so you can't. Did we have any days on the week of the 22nd?
Of November?
Yes.
I have the 22nd only.
Let me just see my thing doesn't go up to that. Let me just. The 22nd of November. I could do any day of the week on the 22nd of November.
So that's also a good week for me. I think Learned Friend certainly can't do some of that week. I don't know if there's some days that week.
I can do only the Monday, and then I have a High Court trial the whole rest of the week.
So that would give us 1 day, which is the 22nd.
Well, what about Friday the 19th then?
Yes, I can do that. So I could do 19th and 22nd.
Okay, shall we do that then? And I'm assuming it will be a virtual inquiry again, as we're doing today. And the arrangements will be for the council to make for this as well.
Yes, I think we're content with that.
The exchange of information. What I sort of think at the moment is how quickly could all the actual papers that you're relying on be sent to the appellant?
Well, so we're not really relying on papers, we're relying on the absence of papers. But we can, I can take the file and the documents in it through to my clerks, and they can photocopy them now. Some of them will need to be photocopied in parts because the plans are whatever twice A1 is at A0, and we can't photocopy A0 here. We can only do A3 max.
So I'm surprised it's the absence. So does the absence of paper mean it wasn't done, or could it just not be there now?
Well, we say that the discharges would be there if they existed.
Okay, that's fine. Then I think any physical evidence that you're relying on ought to be forwarded to the appellant immediately.
Yes.
So can I ask you just to adjust that, rather than the evidence that the council are relying on, the file as a whole, because there may be material otherwise that they discard that we might think is quite useful.
All right. So can you send the file to the appellant as soon as possible? I think that will then
File and the documents within it.
yes. I think that will then prepare them. Then we need to arrange for you to make your case. Really, I think. Do you object to doing it so it's not a mutual exchange? If you just send the council's addendum to the appellant and then the appellant's reply, do you have any objection to that?
No.
Okay, then let's just see. What I would say is immediately send the documents. Then I would say 3 weeks. That would take us to about end of September. So if you say 3 weeks to do would 3 weeks be adequate to do the addendum?
Yes, I'm sure it would.
Okay, and then I would give the appellants another 3 weeks to do their addendum. Where does that take us?
So that's the 14th of October and the 4th of November.
Yeah, so that would suit the 19th of November start.
Yeah, and so if the council are going to rely on authorities in respect of this point, can I ask that as part of the addendum, those are produced rather than having another episode of the authorities being sent through late in the day, please?
It would help, Mr. Obviously, I got a little cross early because it does cause so much difficulty if you don't know what the case is before we start. Because even at the beginning of the day, I said this is the main issue, and you didn't correct me that the lack of permission was clearly a main issue as well. So on that basis, is everybody happy with that? What we will do is we'll get it set down in writing and send an email out to everybody to when it's all going to be adjourned to and what the programme for the exchange of documents is.
So that's fine. The one thing I will say is I'm very happy to send cases. I think it might be helpful if that is in a separate note from the proof, because of course the law and evidence are different.
All right. But if you can just send them at the same time.
Yes, absolutely. I just didn't want essentially to put in a witness's mouth words which are not his.
No, that's absolutely right. Then, is there anything else anybody wishes to say?
I don't think so. So would you just give me a moment while I'm not being in the same room as my team?
That's right. No,
so can I, whilst I'm perhaps I just ask my instructing solicitor who's listening, just to message me if there's anything else she wants me to raise. Whilst we're waiting for that, can I raise one formality, really, I think, which is that technically speaking, of course, Mr. Sutton is technically in purdah, but can I invite you, so long as my learned friend agrees, to treat him as not being in purdah now, certainly so far as, generally just not in purdah now, because I'm going to have to liaise with him over the next few weeks, obviously.
That is fine. I don't think, to be honest, anything of any merit was covered. It was more confirmations of the situation.
Yeah. But it's question number 3, I think. So.
Yes.
So if that's all right with you, then, Mr. Dreden, then yes, Mr. Sutton, you're not.
Yes, so that's fine. We were certainly on my topic 3, and I have a note of what we said, and I don't mind anything else being discussed.
Yeah, and so before we just sign off on the dates, can I? I'm so sorry. Just ask if my instructing solicitor can just have a few minutes just to check on the dates from the point of view of the rest of my team, because I've been busy saying when I'm available from our side, but without checking with them.
Do you want me to adjourn for 10 minutes? And
That would be very helpful
I
indeed.
think if I adjourn for 10 minutes again, and then everyone can just check it around, and then if it is okay, then come back. So it's now 15:25. If we resume at 15:35, so the inquiry is adjourned again. Thank you.
Thank you very much.
Hello, the inquiry is now resumed.
So thank you very much indeed. I've checked at my end and
Hold on 1 second, I'm not sure the council are back yet.
Ah.
Sorry. It's very difficult, isn't it? I find it very hard to come back from an adjournment to see a blank set of screens and not knowing what to do. Thank you, Mr. Stratton. Please carry on then, Mr. Grant.
So thank you very much. We've checked those dates at our end and that there are no difficulties so far as that's concerned. So thank you very much indeed.
Oh, that's good. And it's all okay from the council's point of view?
Yes, sir.
Okay, I will get an email sent around just to set out what we've agreed, and I will see you all in November. So thank you very much, and the inquiry is now adjourned.
Thank you.
Yes, sir.